Let me formally welcome you to the 6th induction program for newly appointed or elevated members of the bar into the inner bar. That's, of course, will not be completed until next Monday, when you are formally sworn in. And we pray that all will be well with all of you. Now that prayer is very significant because we've had incidents in the past when some went through this program and yet were taken off the list before swearing in. So that's why I said the prayer. Maybe you didn't understand. I'm not a pastor. It's just that it's my wish that all will be well with you. Thank you very much. We are starting right away. I will also apologize or plead guilty to not being dressed in a regulation dress. Because, well, not the way we know it. I should have been in a white shirt. For some reasons, I just changed my mind at the last minute. Only to remember that, wait a minute, I'm going to face members of the profession. So let me plead guilty and apologize for that. We intend to keep to schedule all day. And that's again significant because this is the body of Senior Advocates of Nigeria where things are done the proper way. So we'll adhere to time strictly and get through all the programs. I will call on my colleague, Professor Fabian Ajugu, Senior Advocate of Nigeria, to come over and give you more details so that we get the program going. Thank you very much.
Thank you very much, Professor Leonard Silk. I'm all here present, Leonard Senior Advocates of Nigeria, their colleagues. I offer you a warm welcome to the mandatory induction program for newly elevated members of the profession, inner bar. As my brother Silk just mentioned, there's a reason why we ought to do things properly. There is order in heaven, so there must be order on earth. And it's our commitment to discharge the request of the then chairman of the Legal Practitioners Privileges Committee and Chief Justice of Nigeria at the time, the Lord Justice Anogen, where it was proclaimed that this program will be a precondition to being sworn in as Senior Advocate of Nigeria. So the essence of this program, that is my responsibility to convey to you. In his response to the question why he was quitting practice shortly after being elevated to the inner bar in 1978, the sage, Chief Obafemi Awolowo, SAN of blessed memory, responded saying, there was nothing else left for him to be or become as a lawyer, save upon a higher duty to go and serve his people. It is the first segment of that expression that I'd like to focus on. This is something to be thankful to God. Congratulations. There is now nothing left for you to be as a lawyer, other than things that are of higher calling. And so what it means is that you've attained the peak of your profession. You're not going to be SAN squared. You are not going to be anything more along that line. You may have other appendages, you may have other accomplishments, you may become wealthier, you may become more socially responsible. But in terms of the profession, this is the zenith. This is the peak. And so this program is designed to let you have the benefit of members of the inner bar and of the bench tell you what is their expectation. How do you wear the rank? When you're going to take your oath, which I will share with you in my session later in the day, you will be swearing to uphold the following things. First, the Constitution of the Federal Republic of Nigeria. You will also be swearing to assist the courts. In that sequence, your client wasn't put first, to assist the courts, because you become a leader, a bar leader. The Legal Practitioners Act has just tossed you higher than a lot of the people who were called to bar at the same time they do. You have become their seniors in that sequence. The table of precedence is in the Legal Practitioners Act, with the Attorney General on top, with the Attorneys General of states in the order of their seniority as senior advocates, and then senior advocates of Nigeria in their order of seniority, and they were sworn in. And so it is important that we understand these duties. And then, of course, to carry the rank and the dignity that follows it. I want to emphasize the rank and the dignity of the rank. It is this phrase that is the thrust of this program. The rank and the dignity of the rank. What is that? It means that you will need to be seen as an SDN. Be and be seen as. It means that people will now judge you by much higher standards than they did last week or before the announcement. It means that there are now those who would wish to see you perform like they think you ought to perform. It means that junior counsel will prepare even harder with a view to, yes, I dealt with him, I got SAN on the other side. It means that judges will expect so much more from you. Where the rules say you have 20 minutes to adumbrate, as a member of the inner bar, you shouldn't need more than 15 there. It just means your standards got much, much higher. It also means, perhaps in a lighter mood, that some clients may not come to you anymore. They may think that we're not able to afford it. But it's a compliment. I quote from the words of a man I have so much respect for, Are Alfred Babalola, and he said, "It is not a compliment that you are an affordable lawyer. In fact, it's an insult that you're a cheap lawyer. It is not a compliment that you are affordable. It is a compliment that you are an expensive lawyer." And always remember that. Charge your fees, for you have earned it. Do nothing to undermine the dignity of the rank. Throughout the sessions, which have been carefully curated for you, you will be dealing with issues of excellence, because that is what the rank depicts. Excellence at the inner bar. You will be dealing with issues of ethics. And ethics is not technicalities of law. Ethics is doing the right thing at the right time, at the right place, and consistently. Not with an exception on Thursdays. My brother, Mr. Sarah Ehoba Menesian, will be taking you through some of those rudiments in the finest details. You will also be talking about assisting the courts and deference to the courts, respect. One of our highly respected members of the inner bar did mention to me, says, I asked him, yes, if you check my calendar on on suit number FHC/this, it reads 8:30 a.m. That is the time to be in court. 9 is when the judge sits. He arrives, Chief Olani Bekwese arrives court 7:45, sometimes 7:30. And I asked him, yeah, we're of the same view, but why? He says, big men don't go late to events. So consistently, your actions to the finest details must reflect the dignity and the rank that you wear. And sometimes when people have said they qualify, but they were not appointed. And the question is why? Now, of course, barring anything negative, was because some people were seen not to be able to wear the rank. Yes, he has scored A's, he has done 15 cases, he's qualified 6, but they were not able to wear the dignity, the courage, leadership. So we will talk about duties to fellow counsel. On the other side, you will be availed of the dress code for senior advocates in Nigeria and decorum. It says dress code and decorum. And now decorum is very important. And the reason is this. It used to be called the tragedy of commons, meaning one person's misadventure touches on all of us. Which is why if one estate agent dupes someone, the rest of us complain that these estate agents can be trusted. For them to restore the trust, they as a body must single out the one who has misbehaved and sanction him or her. And then they restore the confidence of the whole on the whole. So we will be touching on issues of discipline. The rank is a privilege. It is not a right. I like to emphasize that. It is a privilege, and that's why you applied to. You were filtered by. You were interviewed by, and then conferred this great honor by the Legal Practitioners Privileges Committee. It's a privilege. And what that means is that that privilege can be withdrawn. As a matter of fact, this body, the body of senior advocates of Nigeria, did recommend procedural rules for the withdrawal of the rank of senior advocate of Nigeria. And that includes suspension, admonition, and withdrawal. Absolutely. It's a beautiful day. I don't want to start with this, but I just thought I should mention it when we talk about discipline or when things go wrong. This body has got the ethics committee that deals with complaints, not necessarily by clients of senior advocates of Nigeria, but by members of the public at large. Anybody, landlord, neighbor, students, clients, community leaders, different people. And all that the person needs to show is that the conduct of this person is not in sync with what we expect of all others who wear the silk gown. So, again, back to the thrust of this is to emphasize professionalism, excellence, ethics, to be the hallmark of a person who walks and stands as a senior advocate of Nigeria, SAN. You would already have perceived the difference. And not only are you expected to walk that talk, but to carry oneself and be able to point out to colleagues who may be straying. Sometimes people stray for simply not knowing. not that they intend to. So part of the discussions you would have this morning would be on being mindful. You will be taking through presumptions and rebuttals of those presumptions. You'll be taking through duty to court, to clients, to colleagues, and how to address them. You'll be taking through, of course, issues. I know towards the end, I often will get the questions about billing. Yes, billing is very, very important, right? Billing is very important. And so it's something that you do want to consider and consult colleagues on. Definitely your billing will change. And when you travel or you're anywhere, people should see that this indeed is a senior advocate in Nigeria. It means perhaps your mode of travel also changes, huh? I see Mr. Baby laughing, but yes, your mode of traveling will change as well. Now, we will be also hearing from some of the most senior members who take out the time to come and share experiences with you. But there's something which I'd like to mention while we emphasize the point on excellence. Aristotle makes the point, and I quote, he says, "Excellence is never an accident. It is always the result of high intention, sincere effort, and intelligent execution. It represents the wise choice of many alternatives. Choice of many alternatives. Choice, not chance, determines your destiny." Professor Nadekot mentioned in his opening that there are some people who have gone through this program, 2018, 2019, and they were not sworn in. But the choices they made, short-term choices. One insisted on filing applications that he didn't need to anymore in his life. Someone took a shortcut somewhere. Someone did something funny and thought it wouldn't be discovered. And I'd just like to end on this note. If a man already eats 3 square meals, he needs to make a choice if he needs the 4th one, especially if it might be a fishbone. So at this attainment, I would like to congratulate you again and tell you the essence of this program is more informative, experience sharing. May I request on that table, I'll be happy to give up my seats than see you squashed. This is part of what I'm talking about. Please take my chair on that middle table. Are you squashed? Yeah, if you are, please come and take another. You see, you are now members. You also point out little things like that to our colleagues. So please welcome to this program. Enjoy it. Share experiences, ask questions, listen to colleagues, and listen to the rich set of facilitators who have devoted their time to be with you here this morning. Thank you very much, and the program begins. Please settle down, and can we please minimize movements? Our first session has a thrust. It's a panel. I will just mention the members of the panel and then invite the first facilitator. This session looks at legal practice as a senior advocate of Nigeria. The practice will change, and you are meant to change the face of your practice to now wear the look. And you will have a rich panel of very distinguished senior advocates of Nigeria. Mrs. Miena SCN. We'll be talking about a relationship of senior advocates with the courts. The Senior Advocate of Nigeria, a rebuttable presumption of excellence and scholarship in legal practice will be taken by Mr. Osaro Ebobamen SEN. And after a stretch break, you will look at the client-attorney relationship, and that is to be fed by my brother, Sir Olumide Shofowora SEN. Out of protocols, they actually breached protocols. Permit me to first and foremost, albeit late, recognize and introduce the Secretary of the Body of Senior Advocates of Nigeria. He administers BOSAN, Mr. Olumide Shofowora. I can only commit this kind of errors because it's my brother. So, fully invite to the podium Mrs. Mia Essien, Senior Advocate of Nigeria.
Ladies and gentlemen, by this time next week it will change, but right now you're still ladies and gentlemen. So I'm here to talk about the relationship of senior advocates with the courts. And I think it's quite befitting that we start with the courts, because none of us would be senior advocates if the courts did not recognize our excellence. If the judges, if the justices didn't give us recommendations, we wouldn't be here. If we didn't carry our wigs and gowns and go to court, we wouldn't have the cases with which we would have met the criteria. So it's quite befitting for us to start with the relationship of senior advocates with the courts. I have 25 minutes and I don't intend to use all of them. I have a paper which can be uploaded at some point. So without further ado, I'll start off. So the rank of Senior Advocate of Nigeria is a privilege conferred on members of the legal profession who have been found by the Legal Practitioners Privileges Committee to have distinguished themselves or excelled in line with the criteria set out in the guidelines by the LPPC. Without privilege, there are certain rights that inure by virtue of the conferment. Of course, one of the most common ones we're used to is sitting at the inner bar or on the front row. The sub-theme I'll be discussing is the relationship of senior advocates with this court. And I am definitely of the view that we can't do justice to this topic, no puns intended, without considering the role of senior advocates in the administration of justice, bearing in mind the critical role and symbiotic relationship the bench and the bar have in the administration of justice. And I'll start with considering paragraph 2 of the current guidelines, and it says this: the award of the rank of senior advocate shall be based on the following principles. A, the award shall be an independent indication of excellence in the legal profession. It is to provide a public identification of advocates whose standing and achievement will justify an expectation of the part of clients, the judiciary, and the public that they can provide outstanding services as advocates in the overall best interest of administration of justice. And then paragraph 3 states that the Legal Practitioners Privileges Committee shall exercise full control and management of the process of appointing and preserving the dignity of the rank of Senior Advocates of Nigeria. The primary mode of consultation, and this is where I want to emphasize, will be by way of confidential reference from judges of superior courts, including the justices of the Supreme Court, Court of Appeal, as well as chief judges of states, not as primary means of selection of candidates, but more as a final check in the selection procedure. Paragraph 3.2 then provides that the primary mode of consultation shall be obtaining the confidential references from at least 10 judges of superior courts of record before whom the candidate has appeared in contested cases of significance, and then 5 of them will be selected at random for a confidential reference. From this, it's clear that judges and justices have an indispensable role to play in the appointment of senior advocates. It's therefore logical that as senior advocates, we must have a good relationship with the courts and how it's supposed to be. So firstly, you can't be an SAN if you're not a legal practitioner. It's just logical. And therefore, you are bound by the rules of professional conduct. Absolutely bound by those rules. Now, the duty and obligations of us as legal practitioners are set out in our rules of professional conduct. And the courts expect you at all times to be an ambassador of those rules, complying with the rules. And if you see people who don't comply, you do need to point out that as well. Secondly, you couldn't have attained the rank if those judges and justices did not give you favorable recommendations, which means you had to impress them with your intellect, with your intelligence, with your diligence, with the manner in which you conducted yourself in court. Now, our rules of professional conduct have made specific provisions which detail the relationships we have with the court. And I'll draw your attention to a few of them, quite a number, but I'll just draw your attention to rules 30 to 38. Rule 30, a lawyer is an officer of the court, and accordingly he shall not do any act or conduct himself in any manner that may obstruct, delay, or adversely affect the administration of justice. 31.1, a lawyer shall always treat the court with respect, dignity, and honor. Where the lawyer has a proper ground for complaint against a judicial officer, he shall make his complaint to the appropriate authorities. Except where the opposing lawyer fails or refuses to attend and the judge is advised of the circumstances, a lawyer shall not discuss a pending case with the judge trying the case unless the opposing lawyer is present. A lawyer shall not deliver to the judge any letter, memorandum, brief, or other written communication without concurrently delivering a copy to the opposing lawyer. And then Rule 32 deals with candid and fair dealing. In appearing in his professional capacity before a court or tribunal, a lawyer shall not deal with the court otherwise than candidly and fairly. In presenting a matter to the court, a lawyer shall disclose all legal authorities, the identities of the clients, and so on and so forth. It's actually quite detailed. You should comply with the known local customs of courtesy and practice of the bar of a particular tribunal without giving to the opposing lawyer adequate notice of your intention not to comply. And it's quite detailed. I suggest you familiarize yourself with it. I'll refer to Rule 33, which one of the justices of the Supreme Court had cause to refer to publicly in delivering a judgment not too long ago. A lawyer or law firm engaged in or associated with the prosecution or defense of a criminal matter or associated with a civil action shall not, while litigation is anticipated or pending in the matter, make or participate in making any extrajudicial statement that is calculated to prejudice or interfere with, or is reasonably capable of prejudicing or interfering with the fair trial of the matter or the judgment or sentence thereon. 34. A lawyer shall not do anything or conduct himself in such a way as to give the impression or allow the impression to be created that his act or conduct is calculated to gain or has the appearance of gaining special personal consideration or favor from a judge. 35. A lawyer appearing before a judicial tribunal shall accord due respect to it and shall treat the tribunal with courtesy and dignity. Courtroom decorum. When in the courtroom, a lawyer shall be attired in a proper or dignified manner and shall not wear any apparel or ornament calculated to attract attention to himself. B. Conduct himself with decency and decorum and observe the customs, conduct, and code of behavior of the court and custom of practice at the bar with respect to appearances, dress, manners, and courtesy. C. Rise when addressing or being addressed by the judge. D. Address his objections, requests, arguments, and observations to the judge and shall not engage in the exchange of banter, personality, display, arguments, or controversy with the opposing lawyer. E. Not engage in undignified or discourteous conduct which is degrading to a court and tribunal. And not remain within the bar or where the lawyers were when conducting a case in which he is a party or giving evidence, and so it goes on and on. Now, why am I highlighting these things? It's really sad that I have been in court on a couple of occasions when, after attaining the rank, a couple of senior advocates, when they now get to court, when they are talking to the court, they then put their leg on the chair, as if they are watching one of those procedurals you see on TV. And this is something they wouldn't have done before they got the rank. So what is it about us that makes us change? Once you're conferred with the rank, you suddenly think it makes you a superhero and you're not bound by the normal rules. It's really very it's sad, but a lot of people do it. A lot of people talk to judges and justices disrespectfully just because you've been made a senior advocate of Nigeria. And that is wrong. It can be taken from you. And with what has happened in recent times, there's been a progressive, you can see it's, now we have the rules. And before, there were all sorts of technical objections, and all those technical objections are now being blocked. So as you are being conferred with a rank as a mark of excellence, it can also be taken from you. And we all know some people who it's been taken from or suspended from. It's all out there on the internet, so one doesn't have to go into details. So don't think that once you've attained it, that's all there is to it. You have to maintain it. And you have to maintain that same relationship you had with those people that recommended you. People stuck their necks out and said, this man is deserving, or this lady is deserving of the rank. Why should you suddenly change? Professor Fidel Sodita, QCSA and KCSA, noted in his paper, The Evolving Role of Senior Advocates in the Administration of Justice and Nation Building, that courtroom displays of theatricality and emotion are likely to be received with amusement today. Advocacy is now largely a matter of fact, built on the 3 pillars of competency, preparation, and integrity. There is now more attention to detail than was oratory. And he went on further to say, in Nigeria, the privileges attached to being a senior advocate are largely statutory rather than conventional. They derive in part from Section 5(7) of the Legal Practitioners Act 1975, and in part from the Senior Advocate of Nigeria Functions and Privileges Rules 1979. 3 privileges are conferred: the right to wear a silk gown, the right to sit at the inner bar or front row, and the right to mention cases out of turn. And it's very important for us to emphasize the point that your rank can only be exercised in court. It is in court, not in the marketplace, that you can sit at the inner row. Nowhere else. And so you must give the courts, the judges, the justices, the judiciary their due. And so part of what you need to do to assist the court to achieve the objectives of civil and criminal litigation, which is a just and efficient disposal of cases based on courtesy, modesty, honorable and sound judgment. As Chief Justice Onoge, as he then was observed during the swearing-in of SANs in 2017, the senior advocate must never abuse his position or regard his rank as a weapon of intimidation or a license for weakness or arrogance. So the internet is awash with people whose names have been announced, but they were not sworn in for various reasons. You can get the information on the internet, so I won't go with that. But it's important to bear in mind that the rank can be withdrawn for several reasons, including under paragraph 26(4) of the LPC guidelines. When the person is adjudged to have conducted himself in a manner incompatible with the dignity and honor of the rank, or be found guilty of professional misconduct by the Legal Practitioners Disciplinary Committee or any other professional body from any jurisdiction in or outside Nigeria. And so I've been in court on several occasions, in particular the Supreme Court, where Honorable Justice Larry then said to a senior advocate who was brazenly arguing what he knew was false, that she was going to report him to the LPPC if he continued that line of argument. And when she said that, we stopped it. So it behoves you to always be forthright. You don't lose anything by being forthright. I was in court once. I had a matter, and they had to do, the issue at that point had to do with whether or not a governor had been properly served. And the ministry filed an objection challenging service. And I had done all the permutations. And I decided it was best for me to concede. And so when the matter came up, I conceded. I said to the court, my lord, service was not properly effected. No objection. And we went back to the drawing board and I moved on. It was about 10 years later that I was somewhere else, and a judge came up to me and said, Mrs. Essen, I'm sure you don't remember me, and I apologized because I didn't remember him. And he said, I was on the other side in a matter, and I had an objection to your service, and you conceded. So there were other judges around. It was at a conference. And so he turned to them and said that was the first time he had ever seen that happen in practice. And, and they were all surprised that I conceded. And so, it's all about doing the right thing. I did it not because it was just the right thing, but I knew they were going to go on appeal. And I didn't want to get bogged down with an appeal. So it made no sense. I had done my computations, my permutations, and I knew the best thing to do was to just go back to the drawing board and read a fresh. But I didn't realize that it had gotten me some laurels. So this judge probably had been saying positive things. Well, I hope he had been saying positive things about me based on that experience. And it's something, sometimes just do the right thing and don't look at what other people are doing. When people are doing the wrong thing, you just follow them on that path. You don't know whether you're the one that's going to get stuck there. And so, just before I wrap up, I'll just point out a couple of key things, takeaway points from our discussion. The rights referred to, and I've said this already, are only exercisable in court. They inure to you because of that privilege. And while you may have that right, especially when it comes to, and the rules are specific, it says motion. It doesn't say matter, it says motion. It's quite specific. Out of term. It's important to remember that when it comes to precedence, the court is still the master of its own court and can decide not to. Now, you do have that right, and most times the courts will allow you not just mention your motions, but even your matter for hearing. And there's a reason why they do that, because they want other lawyers, junior lawyers, to learn from you. And so if you just take a motion and leave, younger ones are not going to learn from you. So they tend to allow you, most times now you mention everything you're involved in and do your matters and go. But actually they will say motion. And so if you find a judge insisting and saying, look, it's only a motion, I'm going to allow you to, you need to know exactly what you can push. So it may well be that the court may have omitted to recognize you. Occasionally it happens. However, courtesy demands that you raise it in a polite manner, especially in courts that are so congested that sometimes members of the outer bar may be seated with you and it may be difficult to tell. A lot of times I sit on the front row and as I'm sitting down there, I don't know whether it's my hair or what. I've had very young lawyers ask me to shift, let them sit down. So it happens all the time. It occurs regularly, and then my juniors who are behind will just talk to the person and say, she's an essay. That's when they now see the dangling bit. Oh, I'm sorry, man. And then, so sometimes people don't know you may be out of jurisdiction. Just take it in good faith. The point is, that's not what's going to take your rank away from you. You wear the rank, you have the rank, and all these things are just like slots. You are an officer of the court. You must be respectful. As pointed out, not deliver correspondence without address to the judge or communicate directly with the judge. There are times we hear lawyers are writing letters directly to the judge. It's rude. It's unprofessional, and you could be sanctioned for that. You have to be candid and fair in dealing. If you know an authority in a matter you are doing, you have a duty to disclose it. So you disclose and distinguish and get that out of the way, rather than a court feeling that you deliberately withheld that. Trial publicity. Don't give interviews while cases are going on. It's really very common these days, and it is wrong. Social media posts, all those things are wrong, and you should know better. And you may decide, well, the other gentleman did it, let me do it, You may be the one that may face the consequences for it. And I'll read what Oluwemi Mokunde said in an article, the Senior Advocate of Nigeria, Pillar or Predator, in relation to what happened in an election matter, citations applied. The next point to consider is how senior advocates engage in legal issues of public interest, many of which are political. I'm not as worried about the expression of conflicting opinions as I am about the haste in airing the opinions publicly. I cannot easily recall whether the legal titans of the past, Chief Rotimi Williams, Chief G.O.K. Ajayi, Dr. Mudiaga Ojie, GRIA Gonu, Alhaji Abdul Razak, were quick at grabbing the next available journalist to grant interviews and express conflicting opinions in the print and electronic media. With judges, the lawyers, and tribunal, make sure you don't give the appearance you have a special relationship with the court. And when you announce yourself, you don't have to add SAS because the judge knows you are an SA. And I've heard people get up and say it's also SAS. It's not strange. So you laugh now, but don't be surprised. Courtroom decorum, we've talked about that. Dress properly, serviceable shoes, socks, ties, and all that, and so on and so forth. So, let me conclude. There is no doubt that the bench and the bar have a symbiotic relationship. As senior advocates, it behoves you to ensure all due respect is accorded the courts and to point out to junior counsel where they may have erred or are erring. As senior officers in the Temple of Justice, that is what is expected of you and to ensure the dignity of the courts. And so from the above, there is no doubt that as senior advocates, your primary duty is to uphold the sanctity of the courts and to act at all times as an officer of the said courts, leading by example. You must lead by example, very important. Bearing in mind that some privileges can be withdrawn should a judicial officer complain to the LPPC or the LPPC about your conduct. So once more, ladies and gentlemen, congratulations, and I wish you all the best in the next phase of your professional life.
I was nominated to deal with this controversial topic. Whether your elevation to silk and your distinction is a matter that the public considers to be a myth, or it's one that is reality. Before I start, I think what I will do is to bring my personal experiences and perhaps hazard a guess as to why I was chosen. And there are 5 or 6 reasons that come to mind. The first one, perhaps, is that on the 16th of December, I will be 15 years as a senior advocate. Perhaps my elevation raised a sufficient amount of controversy, and therefore, I've been asked to speak on this topic. My father was a senior advocate and a prominent one from the Midwest, Bendel, and then Edo State. Is it possible that I got silk as a result of his prominence? Did I, or did he unduly influence the process? That came to mind when I was asked to speak on this topic, and I will talk about my experience as we go along. Because I'm going to situate it against the context of the rules. As Prof said earlier on, I'm not coming here to read the rules. That literature is available to be read. The second reason, perhaps, why I've been nominated to deliver this speech, because I consider it an honor and a privilege to sit here to speak to my colleagues. Some of you perhaps older than me in age. Some of you perhaps more experienced. And some of you perhaps a bundle of excellence, far beyond what I can even imagine. Is it because I was called to divine England? I was called to practice in England. I was not admitted to practice. There's a difference. Many of us who go to the United Kingdom get admitted to practice. We're called to the bar and you're admitted to practice in the Commonwealth. But if you elect to practice in England, you go through the practical exercises. My father, a man who I have a lot of respect for, enrolled me at the Inns when I was just 17, I think. Just started my A-levels. What that meant was that I was privileged to be mentored by the likes of Lord Helsher. I had many engagements with Lord Denning. I had spent weekends, that's how the mentorship is considered. I had spent weekends with quite a number of great lawyers and judges that we heard about. At that time, I didn't know Lord Denning was so popular in the Commonwealth, otherwise I would have taken many pictures with him. He was a man who enjoyed strolling at the lawn all the time and he engaged students. The practical exercises was great. If you pass the academic exams and you didn't pass the practical exercises, which meant you spent a lot of weekends away from London. Once were Cumberland Lodge, Induction. And you did a lot of applications and they watched you how you presented your cases. And then you would be scored accordingly. Timing was very important. I saw some people walking here and just strolling in after 9:30. If this was in the United Kingdom, points would be taken off you. And the word senior advocates is coined from QC or King's Cancer. So I want you to consider whether or not the public will consider this to be a myth or a reality. Just by keeping time, those doors will be shut. You will not be permitted to walk past here. Never happens. It's an anathema. The other reason which I think you may have appointed me to speak here, sir, is like that. It's because I am a member of the Convention on Business Integrity. I do apologize. The Convention on Business Integrity, where Bokwan Wishika leads that group. Sojia Pampa is my MD, man who I have a lot of respect for, and I let him become your COVID. And is that the reason why you appointed me to speak on this topic? How does the public perceive you as a senior advocate? What is said to be an equivalent of a QC? Or is it because I'm perceived to have a clear and logical mind? I am perceived to have a bundle or a measure of vicarious experience. Or I'm perceived to string my thoughts together in a coherent manner and have an understanding of the law. That's one of the criteria. Is that why you are appointing this? There's another reason I think you may have appointed me. Maybe as a member of the NJC. Chatham House Rules is speaking here, and it's all confidential. The body that needs the greatest reform, where merits sometimes do not take effect. I'm a member of that body, and you ask me, why didn't you resign? It's a complex issue. Not resigning because I'm introducing a process that will reform the criteria for appointing judges to the Superior Court of Records. Present process is opaque. I believe that every lawyer who's worth that name should not only know the law, what is wrong with the law, prescribe change and participate in that change. So I've decided that I will stay in the NGC, notwithstanding the fact that many times merit is suppressed, so that I can put that in. It's taking me 1 or 2 years. That's the only reason I'm there, otherwise I leave. But I thought, let me make that clear. When you say, as a member of the NGC, what do I do there? I was thinking maybe that's why, Prof, you appointed me here. Is it because I'm a member of the GRP, Justice Reform Project? A group of us came together to say we must do something about these ruts in the system. You cannot be distinguished in a system that is decadent like this. It is dislocated, it is fractured, it is broken. And we say we're distinguished. I'm not sure which one came to first mind, but when he spoke to me privately, he said to me, you are pleasantly becoming controversial. I said, no, if you speak truth to power in Nigeria, you are controversial. That's all that it means. Are you going to speak truth with this gown you're going to wear from them to power? Will you interrogate that shot? So, the way in which I want to approach this, and I'm going to keep it down to 25 minutes. I thought it was an hour 30 minutes, so forgive me if I stray it, because I'm very passionate about this subject. I'll start by looking at the distinction between a person who is fit for purpose, fit to practice, a fit and proper person, and the other qualification is high professional and personal integrity. Fit and proper person is the criteria to be admitted into the bar. High professional and personal integrity is the criteria to be admitted into the inner bar. So there's a distinction between both. What is that distinction? I'll talk about that shortly. Second point that I'll emphasize is adherence to the strict qualifying criteria that admitted you into this bar? Have we followed that criteria strictly, including myself? And I'll explain to you my experiences. And finally, I look at some case studies and see how the issues when you flout the rules, how it's been dealt with, and see the dissonance between how we deal with it as lawyers and how the public perceives us. The difference between a fit and proper person and one who has high professional integrity can be ascertained as follows. A fit and proper person deals more with the regulatory criteria. More or less complies with the regulatory criteria. High professional standards is one who complies with ethical, moral standards. So both qualifications has good character. So you must be a person of good character, the fit and proper to be admitted to practice law, and you must be a person of good character, fit and proper, and high professional standing to be admitted into the inner bar. Which means that it's not about regulatory compliance, it's about ethical nuances that you must have applied to have been admitted into the bar. And we'll test that whether or not we have it. I said there in my slides that individual ethical standard and behavior within their profession, adherence to ethical principles and moral standards, adherence to professional codes of conduct and reputation against colleagues, and your reputation amongst colleagues and peers. How are you perceived amongst your peers? Will juniors sit behind you and gossip and say, you know what, that senior advocate is not who we think a senior advocate should be. You were once a junior and you did it. Don't think it's different. Do you really qualify? So, the difference, however, is that it is no longer your colleagues who will be assessing or evaluating your performance. It will now be the general public. Do they have confidence in this process that has brought you to this stage? And are they trusting of the criteria by which you were elevated to silk to say, yes, this system works? Now, mind you, we're in a very complicated society, so where everything is failing. Therefore, if everything is failing within the society, it's the process by which you were elevated, not also failing. I want you to answer that question yourself. The some of you are sitting here who will be distinguished, no doubt about it, but about some who may have stretched the process, undermined the process, and perhaps abused the process. That is the test as to whether or not you are deserving. And that is the test as to whether or not the reputation still remains real or it's just a myth. So, let me share with you my personal experience. I started to practice law and I was passionate about the practice of law. Once I took up practice, I actually went into business full time. My father wasn't very happy about that, but came back into practice. In no time, many of the judges would invite me to the chambers to commend my performance. One day, the gentleman walked into the office and said, Osara, you don't go and see judges, and therefore it's going to take you 5-10 years to make silk. You better start applying. God bless him, Stephen Colabado. And so I was 38, and I looked at my wire, and I was qualified. At that time, it wasn't as rigorous as what you now have today. I was qualified. 2 cases in the Supreme Court, God bless Mr. Shofunde, my father, so easy to get qualification. I was qualified. And I applied the first time, I applied the second time, because I'd set my mind for about 10 years. So it wasn't a problem. The second time, Justice Whiteford called my father and said, your son seems to be doing well. And he applied for SAC. My father was livid because I never mentioned it to him. So, invited me, as he would always do, to courts. Why didn't I mention it? That I didn't want a situation where the process will be stressed. used. So I understand that, but I mentioned it as quite embarrassing. So we agreed on how we're going to follow the process, not to do anything that was improper through this process. So I'm bold to speak to anyone today and I stand up and say, no, by the grace of God, I made it through. But I tell you something that happened. Justice Adirenu, Justice Oguntade, and Chukwumaine, who sat in the Lagos division, became very fond of me because I was there regularly. On one occasion, I applied and it was said that I was not qualified. But apparently it was a mistake. Some of my cases had not been in the file when I went to check. It was Oguntade who made me know that. So Adirenu had called me one day, Justice Adirenu called, that I should see him in Abuja whenever I'm in Abuja. I had a meeting in Abuja and I told him I'd see him next week. Unfortunately, that meeting was cancelled. Just by stroke of luck, I said to my father that Justice Adirenu had called me and said, whenever I'm in Abuja, I should see him, but unfortunately, I'm not going to be making Abuja any longer. He said, you must be out of your minds. The Supreme Court judge calls you and says, if you're in Abuja, then you better go. And I did go. And something that surprised me happened. As I was walking on the lawn, walking towards Justice Adirenu's office, this was the fourth application. Applied 6 times, yeah. Fifth application. 2 gentlemen walked beside me. The people I know very well, I recognize their faces. And one said to me, Oga, don't come again. Look, I will tell you how we take get sale here. We will take you, go meet Kasinan, who was then the Chief Judge. Chief Justice, thank you. Then Chief Justice. The other one said, now me, they take gifts, go meet judges when people, they apply for it. And I looked back. I said, this is nonsense. Both of you are so silly. I'm going to call the police to arrest you. And they went away straight. And I went to see my Lord Justice Adirenu. Polite man, gentleman, he said to me, do you mind? I'd like to introduce you to Justice Katina Alu. Because I don't mind. Do you mind waiting a little bit? Such a polite judge he was today, Justice Adirenu. Do you mind waiting? I said, I'll wait. And no sooner did we speak, my Lord, the Justice of the Supreme Court, then Chief Justice arrived. And I was taken to him, he said, I've heard a lot about you, but you're so young, don't be desperate. I said, no sir, I'm not desperate. I will do it and I know one day will come. He said, I like your confidence. I didn't get it that year, but I got it the next year. 2 things are born out of that. Because of the procedure and the method by which I chose to be elevated, it makes me bold and courageous to speak about the process. Because I've heard so many things, I don't know how far it is true. If that process, and if I hear that the process, if I believe that the process is stretched and undermined, then those of us who partake in stretching that process and undermining the process, maybe we're not fit to be senior advocates because the public is watching. So if you're not a good advocate, or if you do not qualify and satisfy that criteria, and yet you are elevated, the order of seniority is changed, there's something wrong with the administration of justice. Because when you made silk, what you do effectively is to provide material to the judges by which they will enable them to actually administer law and then define at least policy. So if you don't have the right people in character and in knowledge actually advocating as senior advocates, then you have a problem. So where is the problem? If the system is deprecated, as I said earlier, where is the problem? Is it dependent on the older sales? Is it dependent on the new ones coming in? The question that you have to answer is whether now your allegation is a myth or a reality. The distinction. I want to draw a correlation between how the public perceives this rank and how the public perceives this rank, and the process by which we are now appointing so. For me to do that, I'll use one or two cases that came before the Supreme Court. I think it's Kalejaya's case. Let me explain what I mean. That was a case in which he was accused of stretching the whole system, almost to breaking points. He was accused of interacting with the judge and unduly procuring some political case. He was brought before the disciplinary committee and he was found guilty. He then appealed, of course, to the Supreme Court on the technical points. And I think the reason why the Supreme Court struck it out was that the judge was not sitting on the bail, some technicality. And he was let go, and of course he's admitted. And I say this is a Chatham House rule here. We need to think about that process, because there's a dissonance between how the public perceives us, because those who were affected by it cannot understand how it's back into practice. We lawyers, we rely on the technicality. What I would prescribe, therefore, is that in that situation where there is a gross abuse of the rules, or there are gross abuses of the rules, where there is a clear undermining of the administration of justice, and the evidence is clear. If the Supreme Court were to discharge anybody on a technical ground, he would not be allowed to walk off, perhaps might be reduced slightly. But to do so, to allow him to whack up, just walk away and go back into practice, means that the public are beginning to look at us and say, maybe we have a different rule for what applies, because I don't trust this gentleman I to time. And you know what? There's a tarnish. When one senior advocate tarnishes it, it applies to all of us. You know, there are quite a few stories I have to tell, but I'll just tell you something. I try, very difficult, to try and follow the rules in Nigeria. And if we have to be honest, it is really, really difficult. But we try in our office. We have strong policies. I'm going to talk about the issue of ethical conduct about my good friend's daughter, but I will leave that for another day. But once I was traveling, and I'm very proud to be in Nigeria, but I carry two passports. I also have my Nigerian passport on my right and my British passport. But I'm first in Nigeria, clearly. And when I got to Dubai, unfortunately, the validity of my passports just had about 3 weeks to go, so I couldn't go into Qatar. But I then recalled that I had my Nigerian passport on my right-hand side. And I brought it out because my British passport was to expire. And the gentleman said to me, if I were you, I'll put that back in my pocket. For one moment, I put it back in my pocket. And then I thought to myself, what offense have I committed? I brought it back out. And I said, no, I'm not going to put it back in my pocket. I said, I'm sorry, you haven't committed any offense. But if others call you my friends, they get agitated with the green passports. It is the same thing with being a senior advocate. It's not about just you being excellent. It is about a group, because that's how you are first evaluated. Right. I hear the hint is on, and I must be strict enough. So, I will end like this. I have a lot to talk about. Okay. If I knew it was just 25 minutes, it's only yesterday I realized, so I prepared quite a bit to talk about. How do we cope with a system that has failed, or is broken, has fractured? I've done 3 things. I just run. I run the marathon because of the problems in Nigeria. I just keep running. But as I'm running, I'm thinking, how can I help? So we formed a group together, JRP Justice Reform Project. And we're trying to influence or looking for a way to help the Nigerian Bar Association, because that is another problem, to be able to provide the service for which it is created. The second point is this, and I always say this every time I speak to lawyers. As a senior advocate, not only should you know the law, but you must know what is wrong with the law. And then you must prescribe change, and you must participate in that change. The reason why we're where we are, because most of us, all the lawyers, and the judges are part of us, and I have a lot to say about how the process is now being abused to elevate people to the Supreme Court. My good friend Ajibade, who's there, we share a lot of this because he's involved in the process that elevated. He was, I think, is now left. Please, your duty today doesn't rest on simply advocating the dry law. It is ensuring that the system in which you operate is sufficiently, the environment is sufficiently efficient, is sufficiently studied, such that you can truly say, I'm a distinguished practitioner. Look, the practice of law is universal. So for those of us who practice around the world, what happens is that we are often embarrassed when it is said that he's a senior advocate, said to be an equivalent of that of a QC. That word connotes negativity. It means that you're not really. It is said to be the equivalent of the QC. Finally, please read the P&ID case and see how the Nigerian lawyers were described. I thought I would go into that, but I will not. And you'll be embarrassed sometimes to just have this black skin. So, ladies and gentlemen, I congratulate you. You have a lot of work to do.
Paper is accountability and discipline of the senior advocates of Nigeria, and the main topic is the client-attorney relationship. I congratulate you all on applying the rights, duties, and responsibilities of the lawyer to the client, as most of these have been spelled out in Rules 14 to 25 of the Rules of Professional Conduct for Legal Practitioners 2023. It used to be 2007, or 2023 amended version in statutory instrument number 32 of 2023. And specifically, paragraph 14 deals with dedication and devotion to the cause of the client. Paragraph 15 provides for the duties of the lawyer to represent his client within the bounds of the law. Paragraph 16 talks about representing clients competently. Paragraph 17 enjoins the lawyer to avoid the situation of conflict of interest. Paragraph 18 spells out agreements with clients which must be upheld at all times. Paragraph 19 deals with the privilege and confidence imposed by the relationship with the client. That's quite important. Paragraph 20 deals with the lawyer acting as a witness for a client. Paragraph 21 deals with withdrawal from employment, how a lawyer will disengage from a client. Paragraph 22 forbids a lawyer from calling at the client's house or place of business. Paragraph 23 deals with the relationship between the lawyer and his client's property. Paragraph 24 spells out the responsibilities for the client over litigation being handled for the client, and paragraph 25 deals with investigation of facts and production of witnesses. Having attained the status of senior advocates of Nigeria, you become leaders and mentors in the profession. And it is therefore necessary that a higher standard of ethical conduct should guide and direct your actions going forward as far as your relationship with your clients are concerned. The lawyer-client relationship can be described as a fiduciary relationship. The client reposes his trust and good faith in the conduct and in the hands of the lawyer. As a senior advocate of Nigeria, you are expected to act with the utmost respect for the relationship and may not make personal gains with information acquired because of that relationship without full disclosure. Senior advocates owe a duty to their clients generally and are to avoid conflicts of interest in the client's affairs, to act honestly with his due skill and diligence, and to communicate clearly and honestly with clients, to follow clients' instructions, and to act in the best interest of your clients. In establishing the relationship, when a senior advocate of Nigeria is employed in a matter, it is under a duty to diligently assess the client's costs and make an honest determination of its merits, whether there is indeed a legal claim, the best way to pursue that claim, and the probable results of any action taken. The senior advocate should not engage or encourage a claim with no merits just for the sake and opportunity of presenting a bill to the client. The senior advocate must also refrain from making promises and outcomes that are beyond their control. Where the matter can be resolved through a fair settlement, the senior advocate is expected to advise the client so as to avoid or end the litigation if it has begun. Now, on the issue of fees, senior advocates owe their clients a duty of disclosure with regard to their fees. Clients should know upfront what they will be charged for legal services to be rendered by the senior advocate and what expenses can be expected for each service. The lawyer is expected to send regular bills, clearly setting out charges for each service performed. Lawyers are generally not allowed to take on the expenses of litigation. The client is responsible for such expenses or costs. The lawyer may, in good faith, advance the cost of those expenses as a matter of convenience, but the client is expected to reimburse the lawyer. So you're not supposed to be charitable, unless, of course, you decide to handle the matter properly. Clients are under a duty to pay for the services of their lawyer, although professional rules discourage lawyers from suing for their fees, but a lawyer can take legal action for their fees to prevent injustice or fraud. Subject to these conditions, a lawyer can commence legal action 1 month after the delivery of their bill to the client, either deliver it personally or to their last known address. Several authorities have decided this matter. Now, payment of fees can be problematic in the lawyer-client relationship. Unlike intangible goods that can be repossessed upon failure to pay, usually the client reaps the benefits of the lawyer's intellect and service, which cannot be repossessed by the lawyer. So lawyers owe clients a disclosure on their fees. Clear bills must be presented, and in turn, clients should settle their bills promptly since lawyers also have bills to pay. Confidentiality is one of the most important areas that usually have to be dealt with when it comes to client-lawyer relationship. Senior advocates of Nigeria are under a duty to preserve the client's confidences. All information about the client obtained in the course of the lawyer-client relationship cannot be revealed to third parties without the permission and or consent of the client or under an order from a court. This duty extends to the employees of the lawyer and survives the termination of the lawyer-client relationship. This is a sacred, sacrosanct, and all-important duty. And this duty and the exception thereto are spelled out in Rule 19 of the Rules of Professional Conduct. In a case, Professor Ikeme versus Anakwe, Sanusi JCA held this. The above provisions clearly set out the duty of the legal practitioner A counsel owes a duty to maintain the confidentiality of his relationship and not to disclose any information he came across at the time of receiving instruction of any other or adverse party. A lawyer has the duty to preserve his client's confidence. Such onerous duty starts to exist from the time he was employed or instructed and extends even to his employees. He and his employees alike should not accept any employment which may involve the disclosure or use of such confidence for private advantage of his client without the latter's knowledge and express consent. Confidential relationship between the legal practitioner and his client is presumed to have existed right from the time of the transaction. Also, in Attorney General versus Mulholland and Foster, it's a 1963 Queen's Bench Division judgment in England. Lord Denny, Master of the Rolls, posted thus: the only profession I know which is given a privilege from disclosing information to it because of law is the legal profession. And even it is not the privilege of the lawyer, but of his client. Take the clergyman, the banker, or the medical man. None of this is entitled to refuse to answer when directed to by a judge. Let me not be mistaken, the judge will respect the confidence which each member of this honorable profession receives in the course of it, and will not direct him to answer unless not only it is relevant, but also it is proper and indeed necessary question. It's a proper and indeed necessary question in the course of justice to be put and answered. Apart from the rules of professional conduct, which makes provision for the non-violation or breach of confidentiality of the relationship with the client, Section 192(1) of the Evidence Act 2011 prohibits any legal practitioner, particularly the Senior Court of Nigeria, without the client's express consent from disclosing any communication made to him, cause, and for the purpose of his employment. As such legal practitioner, by or on behalf of his client, Section 194 cannot be waived by volunteering evidence, while Section 195 states that no one shall be compelled to disclose to the court any confidential communication which has taken place between him and a legal practitioner consulted by him, unless he offers himself as a witness, in which case he may be compelled to disclose any such communication as may appear to the court necessary to be known. Another important aspect of the lawyer-client relationship is conflicts of interest. The interests of Senior Advocates of Nigeria or the interests of their associates must not conflict with those of the client. The Senior Advocate should discontinue the relationship if it discovers that a conflict of interest arises because of a relationship with another client, former or current. At the very least, the Senior Advocate must inform the client of the potential conflict as soon as they become aware of it. Since lawyers work under the instructions of the client, Senior Advocates must comply and efficiently carry out the instructions of the client, provided they are in accordance with the law. Clients cannot expect Senior Advocates to break the law on their behalf, and Senior Advocates themselves should not give the clients the impression that they can make the impossible possible, most especially because they know the judge. No legal practitioner is entitled to handle any legal matter on behalf of his client without adequate preparation. Doing so is unprofessional conduct. However, just as a surgeon does not warrant that he can cure his patient, a solicitor cannot warrant winning the case. In the case of Abubakar versus Yaradua, Supreme Court of Nigeria observed it is not ethical for counsel to assure his client that come rain, come shine, he will win the case. Counsel is within his professional limits to assure his client that he has a good case and that he as counsel will do his best to obtain victory. If that is the position, he must stop there and not assure his client that he will win his case at all costs. After all, he is an advocate and judgment is that of the court. By assuring his client that he will win, counsel himself is trying to interfere with the work of the judge. Also in Enoch Koju versus Adeleke, 2007, the Supreme Court said was considering the foremost duty of the counsel to his client and the role of the court to respect thereto. And the court held, counsel owe a professional duty to their clients to present their cases to the best of their professional ability. This is the first and foremost duty counsel owe to their clients. And in the desire and zeal to perform this professional duty, counsel can ask for any relief, meritorious or unmeritorious, but it is left for the court to remove the shaft from the grain in the context of the enabling law and grant or refuse their relief. There are times when the counsel asks for a relief with the full knowledge of the law, with the full knowledge that the law is not on the side of the client. In such a situation, the judge, who in his capacity as the unbiased umpire and ultimate decision maker, should give judgment according to the law, while the parties and the clients of the lawyers, parties are the clients of the lawyers, the law is the judge's clientele and constituency, and he must apply it properly without fear or favor. That is the oath he took on the day he was sworn in as a judge qua judex. It should be noted that lawyers are not permitted to make house calls, not to talk of senior advocates of Nigeria. However, in special circumstances, like in the situation of the age of the client or state of health of the client, or for some urgent reason preventing the client from being at the senior advocate's office, the senior advocate may go to the client's house or place of business to give advice or to take instructions from the client. Apart from monies for fees and reimbursements of expenses, monies received from or on behalf of the client are held by the senior advocate on trust for the client. Those monies should not be commingled with the senior advocate's other funds. Such monies should be held separately in a special account and accounted for to the client. Also, such monies must not be expended without the permission of the client. The legal practitioner should accept no compensations, commissions, rebates, or other advantages from a person against whom he has been retained without the knowledge and consent of that person after full disclosure. When a lawyer collects money for his client or is able to recover property on behalf of his client, he shall promptly report and account for it and shall not mix such money or property with his own. He can only do that. He can only do whatever is covered by his instructions. In the case of MB versus Dominic Intero, the respondent was alleged, among others, to have collected 10 million naira on behalf of his client and failing or neglecting to account for same to the client. He was guilty and found liable for infamous conduct, and he was guilty and found liable for infamous conduct in the course of the performance of his duty as a legal practitioner. Likewise, the legal practitioner should not buy his client's property and at the same time act as solicitor in the sale. He should disclose his interest to his client, ask him to retain another solicitor for the transaction, and ensure that the price paid is fair. The legal practitioner must also fully disclose to his client the compensation he has obtained on account of the client's brief. He must also disclose such money only on the instructions of his client. As stated above, the rules go further to impose a duty on the legal practitioner to maintain separate bank accounts for the money received on behalf of the client, and should make no withdrawal from it unless permitted by the rules. The lawyer who breaches this provision will have his name struck off the roll without necessity for criminal trial or conviction. This is one rule that we are yet to give teeth to in the management of the disciplinary machinery of the legal profession in Nigeria. It is not enough that a lawyer keeps his client's money and was able to pay it back when demanded, but must be able to show through his client's account that he never spent out of it or that the money was actually refunded. The logic of the rule under consideration is to ensure the integrity of the lawyer and that client's money or property is safe within. It is our view that it is not enough to repay the money when requested, but that you have the discipline and integrity to keep such money or property. In other countries, particularly in the UK, it is a serious act of misconduct that you spend clients' money. That is the expectation of our rules, but that is not the way we have been implementing the rules. On communication between a client and a lawyer, apart from the issue of confidentiality, a senior advocate owes the client regular and clear written updates on the progress of their matter. The client in turn must promptly communicate to the senior advocate any changes or information concerning their cause. There is a mutual duty of respect and courtesy. Although, as a professional, the senior advocate bears a heavier burden in this mutual duty. Clients may get frustrated once in a while and may not be on their best behavior. The senior advocate must be patient in assisting the client to understand the law and the legal processes, and in managing their expectations. Respect for honoring agreements with clients is strongly advocated, as it is now misconduct for a lawyer to avoid the performance of a contract made with his client, whether in writing or not. Communication between the lawyer and the client are sacred and protected. Accordingly, it is professional misconduct to reveal all other written communications made by a client to his lawyer in the course of his professional employment. Rule 19.1 of the RPC 2023 makes them privileged communications. Exceptions are, however, created where the client consents to such disclosure. Secondly, where it is made pursuant to the provisions of written or court order. C, where the communication relates to an intention to commit a crime. And D, where communication is necessary to establish the collection of solicitor's fees or in defense of an accusation of wrongful act. Now, how are these duties and responsibilities enforced? Dealing honestly with clients' property is professional conduct, and an abuse of same amounts of unprofessional conduct or professional misconduct. There is a legal practitioner disciplinary committee charged with ensuring that lawyers uphold their duties to their clients and to the profession. Of course, lately we also have the legal practitioners privileges committee being able to sanction and withdraw the rank of senior advocates or suspend, as the case may be, where a senior advocate has run in breach of the ethical conduct expected of a lawyer. There's a case that dealt with some of the rules of professional conduct for legal practitioners, and that case is NBA versus Kadu, 2015. Wait, don't you distracting me. I will finish my book. NBA versus Kadu, 2015, decision of the Legal Practitioners Disciplinary Committee, and the following issues were considered. On duties of legal practitioner, by virtue of Rule 1 of the Rules of Professional Conduct for Legal Practitioners, the lawyer shall uphold and observe the rule of law, promote and foster the cause of justice, maintain a high standard of professional conduct, and shall not engage in any conduct which is unbecoming of a legal practitioner. On duty of legal practitioners, properly account for clients' money or property. By virtue of Rule 23, 1 and 2 of the Rules of Professional Conduct for Legal Practitioners, a lawyer shall not do any act whereby for his personal benefit or gain, he abuses or takes advantage of the confidence reposed in him by his client. Where a lawyer collects money for his client, or is in a position to deliver property on behalf of his clients, he shall promptly report and account for it, and shall not mix such money or property with or use it as his own. On duty of legal practitioner to place client's money in client's account and not mix it with his own, the virtue of Rule 23, 1 and 2, well, I repeated, I said that before. Daudu SAN held, we are in no doubt that the respondent was in a serious breach of the expectation forbidden by the extant rules when he tied clients' monies in polythene bags and made a show of keeping them in lockers in his office. It is compounded that he admitted leaving the sum of 1.2 million naira in his office for 2 weeks without banking sale. Even the illiterate local market trader would have behaved better, talk less of a legal practitioner practicing in the 21st century. Yes, the necessity of maintaining a client's account in a commercial bank is one of the first lessons law school students are taught in professional ethics in the Nigerian law school. And we believe that the respondent passed through this stage. Even if he did not remember his law school lessons, the law is presumed to be in his bosom as ignorantia legis non excusat. Ignorance of the law is no excuse. Now, on duty of legal practitioner not to abuse confidence reposed to him and promptly account for client's money in his possession, the lawyer should refrain from any action whereby for his personal benefit or gain he abuses or takes advantage of confidence reposed in him by his client. Money of the client collected for the client, money of the client or collected for the client or other property coming to the possession of the lawyer should be reported and accounted for promptly and should not, under any circumstance, be commingled with his own. And finally, on the duty of legal practitioner to his client and society, the lawyer occupies qua his client and society a position of trust and fiduciary relationship. The balance of the society will be irreparably damaged if lawyers cannot be trusted by their clients and society. Lawyers must take heed and not play the team god in the society, which is dependent on their knowledge, honesty, and fiduciary dependability. If lawyers cannot be trusted, who then should the people trust? The legal profession should rid itself of dishonest characters in their midst. Once again, I say congratulations to you all, and I pray that none of you will be a dishonest character in our midst, so that you will not lose the honor the rank confers. Thank you very much. All right, I spent 5 minutes extra. I'll pay for it.
Thank you, Mr. Shufowara, for the very illuminating presentation, leading with cases to depict the reality of running foul of extant rules and regulations in the profession, and of course, more so on the part of members of the inner bar. We'll go straight to the interactive session, questions, answers, and comments, contributions. Please feel free. Now, this is your program. It's an opportunity for you to hear your views or ask any questions. And we'll start. We have between now and the next session, we have about 14 minutes. Now, let me explain why I said 14 minutes. Since we have had a stretch break, which more or less equated to a coffee break, and since I have already indicated to you that you have every right to rise as they need may arise, to go out and take whatever you need to refresh yourself. We will not declare any formal session again because it will be too close to the earlier one. So we'll just merge that as part of the period for the question and answer. I hope that's okay by everyone.
It's okay.
Thank you. So we'll go to the question and answer session now. I can see a number of hands. So what I'll do is, let me just recognize those who want to speak, at least right away. The gentleman here, Mr. Akongwe, Mr. Balogun, any other person? Okay. Now the gentleman, sorry I cannot read the name, I can read this because they are so close to me. That's three. Then the gentleman at the rear there, 4. And yeah, 1, 2, 3, 4. At the last segment there. So 4 plus 3, that's 7. So we'll start from here, from the front to the back, and likewise at every row. So we'll start with Mr. Akongwe.
Thank you very much, sir. First, I'd like to thank thank BOSAN for putting this program together on ethics for us, more particularly the resource persons for giving us your time share your thoughts and views with us. I know very well that we cannot afford you if you were to present us a bill for this. So thank you very much, sir. I would like to go straight to the point, and I think the reason why I'm raising this is I don't think there's a better time to do this than on a subject that touches on ethics of the profession. And as a prospective, or let me say, yet to be conferred senior advocates, I think I'd like you to share your thoughts with us on this issue. I think particularly I'd like to direct this at Mr. Ehubami SCN, and who during his presentation told us the roots in the English legal system. Perhaps maybe Mr. Akreli SCN too could give us his thoughts on this. When I was, I also am someone who also studied in England and also did a bit of internship at law firms in England before I came down. And from that perspective, and also from my junior days as a counsel, we heard members of the inner bar refer to themselves as learned friends. And also when they addressed also the outer bar at the time, also addressed us as learned friends. But I think in the last maybe 5-10 years, something that has come up where senior advocates refer to themselves or call themselves learned brothers. And I was fortunate enough one day to be at the Supreme Court when a senior advocate was announcing his appearance and that of his fellow senior advocates and said, I also announced my learned brother, so person, and so person. I remember Justice Onoge, then Chief Justice of Nigeria, said, do you have brothers at the bar? That brother is at the bench, not at the bar. Which for me is in line with my background in the UK legal system. And the answer the senior advocate gave was that no, brotherhood of the inner bar, which has now become something that is now commonplace in the inner bar, LPS on social media and all of that. So please, as the law that wants to come in, can you please educate us and enlighten us on this so that we don't fall into it with a bad thing or a good thing? Thank you.
As time and protocol established, of course, Chief Balogun. Now, my first question is that, let's say, Mr. Osaro, keep on insisting on rules to be followed to become an SAN. Can you marry that with LPPC, Privileges Committee? It is not right. If you are not choosing, can you go to court? So what are you talking about? This must be strictly followed. Discuss with us. Can you marry that? Number two, to learned sick SCN, we are having difficulties sometimes when we're in court with judges and justices. I mean, Mr. to say, 2003, I was going to appeal Ibadan. There was a motion for leave to appeal to Supreme Court. Mixed law of facts. They were insisting I have to also attach the judgment of that court. SCN for Ibadan was forced to withdraw his application. My turn, I said, my lord, I'm not withdrawing. Who are you to tell us to withdraw it? You have seen the SCN. I said, my lord, I'm sorry. I'm harmed here with the case of Clement and Wayahu, who said, do not attach it, it's your judgment. Did it to us. Now, if I don't have that mind to face as a young lawyer, it means I'll just sit down. I will go to. And again, sir, there was another case, because there was experience. I was in tribunal with my brother, the chairman said he won't record me in the days of error submission. I won't record you. My lord, this thing will go on appeal. No, I will send you to prison now. Don't sit down. So because of my background, my boss trained me, my principal. I said, no, record me. I insisted, we were there for 30 minutes. I didn't sit down. My lord, record me. I will be sent to be rude. So in that, what are we going to do? I thank you very much, sir.
Thank you very much for that. Thank you. K.O. Obamboke is my name. And my question, sir, is predicated on
the contribution of my brother from Edo State, Mr. Roy Robert. In the course of his presentation, he made a profound statement that we cannot be distinguished in a system that is broken down. And to drive home this point, I want to give just 2 illustrations, and then I will ask my question. Sir, 2 cases, sir. One is at the Supreme Court now. The dispute in that case is over ownership of a Bedford lorry. We spent 25 years and 3 months in the High Court, 9 years in the Court of Appeal. And today the matter is at the Supreme Court. There is no date. That matter has been on. Second case, sir, a chieftaincy dispute in Edo State. We spent 5 years in the High Court, got judgment in February 2005. We spent about 9 years at the Court of Appeal, judgment in 2014. And the Supreme Court made an order for accelerated hearing in 2016. The matter has come up repeatedly without a hearing. Today, there is no date. Our client who won in the High Court, won in the Court of Appeal, is just watching. The man declared by both the High Court and the Court of Appeal to be an impostor, enjoying the throne. Our system is broken down. This system cannot attract investors. So let us not deceive ourselves. So my question, sir, is how do we revamp our legal system that has broken down completely, with us pretending that the system is working? That is my question. Right?
The question, and mine is just to take on the learned senior advocate Osaro on this point of engaging the bench, precisely because, like the learned seal who spoke first, SAN said, we cannot be senior advocates of Nigeria without the court and consequently the bench. But we also know that it's beginning to be a bit of a problem. We have one method of solving that, at least from the jurisdiction where I practice, which is during the bench and bar forum in the law week. And it's easy to engage the bench. They tell us what we do wrong. We tell them what they could improve on, and so on and so forth. But I think that considering the complexity or the interdisciplinary mode of practice now, we need more measures or more opportunities of engaging the bench in different fora. I would like to know if in other jurisdictions or also from the point of view of the expertise of the panelists, they could also propose more means, more respectable means of engaging the bench in order to improve generally practice in the country. Thank you.
Thank you very much.
Ibrahim Gulu. My question is with regards to the rule on not visiting your client's office. How do we apply this to corporate or government clients? If you are representing, for instance, First Bank, will you insist that the MD must come to your office? Practically.
Thank you very much.
Thank you. My name is Kenwa Jayi, and my question goes to SM, Binaya SM. Now, for the totality of what has been said here today, one thing is sacrosanct, and that's the fact that our new status confers us the right to be termed as leaders of the bar. And I believe that one of our responsibilities as leaders would be to break new grounds in the legal profession. Now, considering the recent trends of the court awarding cost personally against counsel, which has even been done to even some of the most senior in the legal profession, how do we balance this trend with our new status? Thank you.
Thank you very much.
Morning, my name is Johnny Agi. I think 2 of the questions that I was going to ask have been asked by, I think, my brother Konde and my learned friend Lihama. So I think the 3rd question I would want to ask is as regards the issue of counsel addressing the press, particularly when they have cases that are still pending in courts. I recall in the course of, let us say, SCM addressing us mentioned part of it, but I think I didn't really get her exposition clearly. Maybe she should let us know, because it's rampant, and particularly it is members of the inner bar, most often than not, that do this very often. And so I don't know whether it's something that is just because some of these persons are members of the inner bar that there are no punitive measures, because I think it should be discouraged.
Thank you. Before you sit down, is there a distinction between your brother and your other friend? Considering this start, always earlier observation.
Okay.
You described somebody as your Daniel brother, the other one as Daniel friend.
Okay. Well, because we are here to learn, I think from this gathering we'll be able to know whether we should continue in that line.
All right. Thank you. You are so witty.
Good morning, my lords, learned senior advocates. My name is Isaiah Bozima. My question arises both from Mrs. Essien and Mr. Gobamian's interventions. Mrs. Essien regarding the relationship between senior advocates in the court, and Mr. Gobamian regarding the broken system, as it were. Now, I was involved earlier, quite recently, in the case where there was a very high degree of suspicion of misconduct on the part of a senior advocate and two members of the outer bar and the presiding judge. I consulted widely, but was advised not to report cases of misconduct, primarily because I was applying for this rank, and I was told not to get a reputation as one who makes these allegations, and also the need to maintain a cordial relationship. So my question is, how does one navigate the need to uphold very high ethical standards, with also the desirability, if I can call it that, to maintain these cordial relationships between one's colleagues and the bench, particularly when confronted with potential misconduct? I would love to hear Mr. Igobiamen's interventions, but I would also love to hear the interventions of any of the other panelists. Thank you very much.
Thank you very much.
It's more colloquial, but the correct thing is friends of the same. That's that. The second person said we have difficulties with judges, you maintain your stand. Mr. Balogun, I'm talking about you. You were able to maintain your position because you came prepared. The SAN who came before you was not prepared, and so he had nothing to base his pushback on. That's the reason, and that's the only distinction. And from what you tell me each occasion, you push it back. You've been able to justify that. And so whether you're a member of the outer bar or the inner bar, you must always be prepared for your worst case scenario as to what's going to happen in court. And you knew that could arise, and that's why you were out with authorities. So for me, I think that takes care of it. Always be prepared. Today, in hearing cases, Osaro will take that. How do we engage the bench in order to improve practice? I think this is a very knotty issue. The bench and bar forum, I think it works in several other states as well. It's been found to be quite useful, but I don't know how that can happen on a wider, in the wider sense. Perhaps my Lord Justice Faji or Justice Sowa may be able to give us some tips on that. Recent trends of awarding costs against counsel, I think that is correct, because a lot of cases we file are frivolous. A lot of the things we raise, we should not raise. If the Supreme Court, and this is the general principle, if you know that the Supreme Court has held a certain position consistently, why are you going there if there is nothing, have nothing new to offer? So if all your facts are the same as 10 other cases, you are coming to say there is jurisdiction, but Madukolo and the score of cases all say certain things, and you're coming. I think in such cases, they should award costs against counsel for two reasons. One, you advise your client as to whether or not he should proceed with that case. he listens to you or she listens to you. You are the one saying, let us do this. And as long as you're doing something you know you should not be doing, and the courts come to a conclusion you shouldn't have, as far as I'm concerned, council should pay for it. So I am very okay with that, because a lot of the delays we're talking about, your case, your Bedford, that God knows what state it is in right now, is because you've not been able to have that case heard on time because of frivolous cases. And with respect to all of us, a lot of them are there because we need to make up our numbers to apply for SIM. So take a look in the mirror and see what is causing the problem. So delays in the system, my other colleagues will address that. Rule not to visit the client in his office is correct. I don't know why you need to. That's the reality. I don't. And I pay my bills. So the question is, why are you going there? Especially in these days. For me, 99% of my instructions come by email or phone calls. And you understand, if they want to see you, they need to come and see you. Otherwise, you cheaten yourself. If you're going to his office and then you give him a bill for 40 million, you'll be wondering what you do with it. Because you're there. But by the time he comes to you and sees what you have on offer, you charge him 100 million, he will pay and say, thank you for being generous. So you have to position yourself. It's all part of it, positioning. If you look hungry, they'll treat you like a hungry man. I say this regularly, when you attain the rank, your income drops initially. Because the people you were working for can no longer afford you. The people that can afford you already have senior advocates. And so there has to be something about you that sets you apart and makes people want to use your services. So there's going to be that period when you're between and betwixt. That's the truth. And even for a lot of people up till now, they may not necessarily have more clients, but the ones they have are paying them more. I'm very happy to pay them more. Okay? So, so to the gentleman on going to the office, you don't need to go there. If they want you, they'll come to you. If they're not ready to come to you, they don't need you. And as Professor Jobu said earlier on, don't be a cheap, not you in the general sense. Don't be cheap. Okay? Council addressing the press, it's not necessary. That's my opinion. The key cases that are being won and fought every day, you do not have lawyers conducting press interviews. The rules say it's wrong, it is wrong. If you decide to follow those doing the wrong thing, that's for you. As for disciplinary measures, it's easy to say, oh, nothing is being done. But unless somebody files a complaint, nothing is going to happen. So we can sit down there and say, oh, he's doing this, he's doing that, he's doing that. Okay, you are a lawyer as well. You are in just as good a position as to formally put in a complaint. But you're not going to do that. And so it comes to who will bail the cat. And until the cat is bailed, the cat runs free. So that's that. And I think we're advised, Mr. Bazaya, I said Mr. Bazaya, Isaiah Bosimo, you are advised not to complain about the misconduct because you applied for sale. And so you didn't because you were applying for sale. So at the end of the day, every man has a price. That's what it means. What's your price? So the question is, what are we prepared to give up? Were you ready to take the high road and say, I don't care, I'm applying for sale, something wrong is happening, and I am going to ensure it doesn't happen again? You weren't ready to do that. But in all societies, people have to take those steps. Somebody has to say, enough is enough. It wasn't you then. Perhaps it could be you tomorrow. Thank you very much.
People who would understand the nuances, the administration of justice, and the need to maintain sanctions and consequences grown through the ranks all the way to the Supreme Court. when you take up issues like that, people become extremely petty. And so it's a systemic failure that we need to deal with. Where if you take up that complaint, you don't have consequences. Because you're trying to repair the system and then you're prejudiced as a result. I think that there are fundamental issues because I sit to the NGC and I tell you, I mean these are Charterhouse rules, right? So there was a day that I discovered that the council was going to suppress merits and bring in somebody else. I don't look at the names before I go there, so I'm not affected by it. About 3, 4, 5 of us spoke. We spoke adamantly against what was happening. It's clear impropriety, I'll call it. But it went through because in the NGC, you have about 26 people. So 5 people speak. But I tell you what happens next. If you're not careful when you're in the Supreme Court, the insults. Simply because you've taken that position. And God save you, your client's case might also be affected. So, on a lighter note, I was told once to withdraw my statement. And I said, look, my duty is to tell you how the public perceives what we're doing. And what was my statement? I said the public has lost confidence in the administration of justice and confidence in the justices delivering these decisions, especially with these political cases. And the whole place went in uproar. Oh, no, how could you say that? Withdraw your statement? I beg your pardon, I'm not going to withdraw it. I have a duty to sit here to report. But I tell you, it takes courage and bravery. And thank God for my few players who will continue to instruct me because their cases may be affected, I say that. That's because the quality of many of us that transcends the system. The system is not producing the best quality. Therefore, those who sit as judges sometimes have great difficulty in advocating our cases. We just talked about cost. The principle of cost is mostly misunderstood completely. And when you get to the Supreme Court, it's a policy court for Christ's sake. Adopt a brief and sit down. Sit down. There's a lack of decorum between the bar and the bench. And the bench, sometimes you are exposing inadequacies, but the bench takes it negative. And there's this terror of insults, even at the Supreme Court. And I say to myself, some of my colleagues say they're not going there. They will have when last have you been in the Supreme Court? They say they know, but that's not the answer. I will continue to attend the place, but I tell you the price to pay that is huge. So, but I just go on to one other question. We have answers. The administration of justice is different from the administration of the court system. When you leave the administration to a gentleman who's been concerned with the administration of justice all the way, and all of a sudden you're given a huge project to administer the courts around the country, the amount of money that you have to sit over, and you're bringing someone who has no experience whatsoever. This is handled by very experienced people around the world. And we've put it forward that look, you must make that distinction. So even the delays you're talking about, you need experts to look at statistics and look at what we need to do constantly. What we do and why we do it must be subject to constant review. The answers and the solutions and the solutions to the problem are there. The question is, those who occupy sensitive positions, do they have the same mindset that you have? And if people are grown within the system, it's very difficult to do anything that seems to challenge that system that actually got you there. So, as you come in, I just pray that many of you will hold the philosophy that allows for change, because it can be done. Let me just answer very briefly questions that were put forward. Mr. Akongwe, you said the word brother. I never used that word. Law, as they say, demonstrate those who actually practice law and learn it. That word means something. It means you demonstrate scholarship. And therefore, when I meet my colleagues, I talk to them about what new law has just been, what pronouncements have been made either in the Supreme Court in Nigeria or in the UK or in India. But I noticed that sometimes our colleagues, when they need to say, how much have you made? It has nothing to do with money. And so that camaraderie, I saw my father, when he's met his friends, he always talked about the development of Rome. If I meet Demola is talking about, one new editor had written a book, he's a poet, sometimes he's a historian. Everything brought in the one. So we enjoy just speaking about how you write very well. So what brings you together is that scholarship. And when you reduce it to a very casual declaration, I think it demeans the practice. So I will not call anybody a brother. I continue to call you Leonard Silk, Leonard colleague, or I just call you Mr. Akwe. That's what I would do. And I would discourage people demeaning the very high status at which society has placed you. That's the point that I would make. The question about can you marry what I said with the fact that this is a privilege? Of course you can. It's a privilege that is circumscribed by rules. Now, if the privilege is being given based on certain criteria, and you're not following that criteria, what it means is that you are altering the order of seniority using order reason, and therefore people lose confidence in the process, and therefore you're not distinguished. Unfortunately, what we do is predicated on the confidence of the public. For you to administer justice, you need the confidence of the public. So if there's a clear dissonance between what happens in the public, how we are perceived, and what we do in there, then your distinction is diminished. So I don't think that there's a problem saying that if we're going to follow a circumscribed route, only those who are truly deserving should actually be elevated. I will not go into the appointment of judges because I'm working on that and I'm praying that I succeed. That's the only reason why I'm still at the NGC. And I think the NGC will set up a subcommittee now, and I'm working with UNODC to introduce a process that will infuse some level of integrity into the process of appointments. If that works, and we're borrowing from Kenya and everywhere, if that works, it'll be fantastic, and I will know I've done my job. If I don't succeed, then I need to resign. I have no business there. Mr. Bambi, delays. Yes, the system is broken. I feel so sorry when I see cases of this nature. But you know what? When we get to the NGC, where these matters should be dealt with, sometimes the subject of discussion, this particular subject I've raised a couple of times, is relegated to the panel. I haven't met the new Attorney General. I was hoping for quite a few things to happen. It didn't happen. I haven't met the new Attorney General. I intend to meet him. I do that a lot. I just go and see them and say, look, there are things we can do. So I've made a lot of proposals. I'm hoping with the new Attorney General, and I'm hoping that, well, I've raised a lot of things at the NGC, including the lack of civility between the bar and the bench at the Supreme Court. If you go and argue any political case at the Supreme Court, you would not believe you're the Supreme Court. And I use the words at the NGC, we have degenerated into magistracy at the Supreme Court.
Yes, yes.
But I leave the rest to you to decide how that matter is handled. The bar and the bench forum, inevitable. You need it. I know that in Lagos there's been some difficulty in actually having it work, but in the UK, that's in fact it's when you go for dinner at the King's of Court, the public judge sitting next to you and is making a decision and you tell him that this is how it ought to be, without of course seeking to influence it. The other point is this: the Supreme Court in Nigeria doesn't accept academic literature. There's nowhere in the world, if you don't subject your judgments to criticisms and you're not open to those criticisms, that you will make any progress. So some of us go to the Supreme Court and we cite decisions still. I bet you go and read what they said of me when I cited Saka. You go and read it and you see the damaging comments. And it's in the Supreme Court case. So we just need to keep trying. I think it's the training for judges, especially at the apex court. And I feel very sorry for judges who are very hardworking at the High Court and the Court of Appeal, what normally happens at the Supreme Court. And in the Supreme Court, I hear a very good friend listening say that when a decision has been established, when a principle has been established, that's it. In almost all points, now there's a conflicting decision at the Supreme Court. The Supreme Court. And the reasoning is getting weaker and weaker. Just go to look at it. It's a combination of reasons. They're overburdened with work, can't write judgments that will compare to any judgment they were with the type of workload they have. But there's also the issue of intellectual content. When you get to the Supreme Court anywhere, it means you really demonstrated and shown true scholarship. The Supreme Court that I appear with care afterwards. But this is Chatham House Rule, so Ibrahim, I didn't get your question. I think the last question that I talked about is breaking new grounds, cost, and all that, cost against counsel. That is not unusual. If your conduct is at a particular level, cost can be awarded against you. But what I see in the Supreme Court is used as a threat to stop you from even raising matters that are otherwise formidable. You're raising a compelling point. And we're sitting there by watching counsel, sometimes younger counsel, raising a good point. And the Supreme Court will come down on you heavily because they're impatient, because they are overburdened, the docket is full. And at times they're blatantly rude to counsel at the Supreme Court. It's not all counsel who go to Supreme Court are unprepared. So there's a presumption that when you come, especially as senior advocates. But I don't give up. I run the marathon for justice. And finally, I would always seek to co-opt you into the JRP. I have 3 of the members here. A few senior lawyers came together to try and see what we could do about these complaints you're talking about. Once we get ourselves organized the next quarter, I think many more members will be co-opting many more members, right? The last sits over the ethics committee and the JRP. Thank you very much.
So, yeah, today. And that speaks volumes. And also the board of appointments, which I recall years ago, I don't know why we deleted from that. I was discussing the same issue with Justice Owari some days ago. And judges used to be appointed on invitation. Yes. If you get a call from the Chief Justice or Chief Judge that, do you mind joining me for dinner tomorrow or something? Because they didn't used to go to hotels in those days anyway. So, private dinner, otherwise you just softly reveal the intention of his brother basis to you. When you come in on that basis, the likelihood of you're not doing well plummets. But we'll leave that for another forum. I deliberately did not want to interrupt the respondents, even though I knew we were gone beyond time because of the importance of the discourse. And I have no doubt that you are equally satisfied that we've gone that way. I thank Mrs. Mia Essien, who is traveling tonight. She waited for this program because of its importance. Thank you so much, Mia. And I thank Dr. Obamen, who did not even flee. He accepted to interact with you as soon as he was told. Thank you so much, Mr. Aro. And to Mr. Shofora, who is one of us, thank you, sir. He's the boss of BOSAN, so thank you very much. Here in Lagos. Yes. Let's go to As your lordship, please. And he is also a regular facilitator at this program, which I'm sure will benefit a lot from him. And the last but not the least is Mr. Jimola Akinrele, Senior Advocate of Nigeria, who I'm sure will lead in the presentation with practical anecdotes, which I believe you will find very interesting. Welcome, Mr. Akinrele.
Court of Appeal perspective. I think even from previous speakers, apart from our knowledge of the law school and thereafter, we are all familiar with the rules of professional ethics in the legal profession, especially that of the lawyer to the client, the lawyer to the legal practitioner to the court, and the legal practitioner to society. The difference, I forgot to come up with that's entirely contradictory from the bottom of my heart. This education. Yeah, I was going to say that the difference now is that your elevation has taken you to the position of leader in the profession, which of course entails high level of professionalism, comportment, language, and learning. And that while shunning all circumstances of corruption and abuse of office. This I say further translates into punctuality, courtesy, mutual respect, honesty in all its ramifications, including to and in the cause of justice, mentorship, diligence, and integrity. All right? And I have some examples here. I start with diligence. When we are talking about professionalism, there must be diligence. And I'll take through one example I've cited at this forum on some occasions. I was in the Court of Appeal in the Enugu Division in 1 year. I remember I sat with Justices Hakim, now in the Supreme Court, and Akeju, now presiding justice in the case. And there was a motion by a senior advocate of Nigeria, an elderly man also. And I'll mention this, which I'll come back to later. I think we negotiated appearance in open courts there with a junior. I think I'll come back to that later. It's not good for you to negotiate appearance with a junior in open courts. Thank you. It's not good for you to negotiate appearance with a junior in open courts. Whether you are going from Onitsha to Lagos or from Onitsha to Abuja, you should have people that can appear with you. If you sometimes cannot afford your juniors traveling with you. So it was at a time when we were not supporting motions with reaching addresses. And just at the back there, outside of the bar, someone stood up, represented himself, and opposed this motion. The fellow was not a lawyer. He must have been a failed law school student. But that was not his first time here. He has been appearing in court. That was in Enugu. And we look at our faces and it was like, you guys talking seriously. Opposed to actually everything. This elderly senior advocate of Nigeria obviously was not here. It was, don't let me call it a shame. We felt we had to save the profession and we overruled it. That was that. But that's the message I'm passing to you. Liane said it a few minutes ago, like Mr. Balogu, she said that you are prepared. I think you should, don't take your opponent for granted. In an adversarial system, you must always be ready for the game. I think that is very important. I equally cite examples of this one, not a senior advocate of Nigeria, but a senior lawyer in Calabar Division who has this habit of citing cases and he will just say the facts of this case. So. Whatever the other man has written in his brief, nothing to distinguish, nothing to say. Quite totally not intellectual. So that's not a senior advocate, to be fair. And I think therefore, because we operate a brief system in the appeal courts, Court of Appeal, Supreme Court, your brief should be of the highest quality. Should be of the one of your own, Adeju Igbe, senior advocate of Nigeria, had an occasion to comment on the quality and standard of briefs in recent times. And I think, of course, it showcases you. Because many of the times, the justices will have read them before you come in to argue. And even among themselves, see what a senior advocate makes. That type of thing. So I think is a great challenge for you. If you are coming to this, the leadership rank, that you should be very serious, be very diligent. Let your brief show you as an intellectual at all times. It shows the person, and of course, it shows the respect they will have for you. They read your brief before you came in, so they have assessed you before you came into court. And therefore, those type of things you must take seriously. I'll cite an example from the law reports. The Imo election case concerning Uzodimma, the previous one, I think the one again, many lawyers have criticized that judgment. To put it in colloquial language, number one and number four became number one, and they were blaming the Supreme Court. But obviously, you cannot afford to blame the Supreme Court alone for that thing. What happened was that the fellow came from the tribunal to the Court of Appeal, and the Court of Appeal rejected him also. The argument was, gentlemen, I have 388 polling units. Election took place there. All that happened was that at the collation center, it was not recorded. Supreme Court, please add up for me. And then lawyer started, it should not be tendered by a police officer. The Supreme Court said, which police officer gave? The man, there was no argument as to polling units. He said, please do this arithmetic for me. And they did it. Now, other senior counsel came back and said the man did not meet the constitutional requirement of spread in local government. That would have been in a court appeal if you wanted to guide the courts. The moment you receive this brief, you file a cross appeal. Say, okay, even if you accept his mathematics, it is not possible. Then you will have guided the court properly. And then when they say that by addition he won, they will not be able to say returning. That's very important, since you are now senior advocate. You are now senior advocate. Instead of coming out and say number one became four, that should not come from lawyers. You should have read the judgment and see what exactly happened. Yes, they could have had some internal views, but it's actually part of the duty of the lawyer to tell the court. All right? I've always thought, and one or two other speakers mentioned that, those of you who observe the practice in England, for example, of equity, you find a professor of law somewhere or a judge, you cannot, their intellectual capacity seems to be the same. There is no person you can say, this QC is inferior to this judge is inferior to this position, so much so that any person, they can change those positions. A professor could be QC, a QC can be a judge, and so on. When you assess them, I think here too, that's how it should be. That's how it should be. Talking about learning, responsibility and courtesy, I was in Cardinal Division, and a senior advocate of Nigeria came in, and we're talking about, so my Lord, look at my previous affidavits. Even this new version, I'm relying on my previous affidavits. I said, what are you talking about? What are you talking about? You know, that should not be the plight or the utterance of a senior advocate. Do things properly so that the courts will respect you. And then when you insist on doing the wrong things and making noise, it becomes very ugly. It becomes really, really ugly. I said here, instead of considering the man insisted, and of course, we just ignored it and did what we had to do. In other words, don't let temptation make you to fall short of integrity. There is nothing like a good name. As the Africans will say, nothing at the end of the day like a good name. Therefore, and in terms of leadership and mentorship, I conducted a small research among lawyers, including SENs, and I said my question is, what is the most important thing these days that can make a lawyer excel? And almost all of them answered, technology. Technology. Acquire new skills so that you can expand your scope of practice, transborder practice, get involved even in trainings that can take you outside of the traditional practice, so that there will equally be economic stability, and so on and so forth. I remember a debate at the body of benchers on one occasion, and we're talking about increase in lawyers, that the economy is not too good. And some, none of them are SCM, but they're practicing lawyers in Lagos. They boasted that there's nothing wrong with the economy. It's about skills. So I say, you guys, why don't you teach the others these skills that will make the economy good? And one of them, like I mentioned, is Abata and Tommy. I said, why don't you teach what is lacking? Those of us that are teachers, then what is this skill? Tell us, we are going to teach them, and so on and so forth. So I think you should expand your base. Expand your base. Many of the things, some of the things to emphasize in those areas are about timelines. You find out that even some lawyers do not know the timelines for filing interlocutory appeals in election matters. So I think with your status, you should not take any of these things for granted, so that you will not at any stage be embarrassed or taken aback, so that you will be on top at all times in your new career as senior advocates of Nigeria. Once again, I congratulate you.
Justice Olanika to come and give us thank you, my lord.
Thank you, sir. I want to say that it's a huge privilege and great honor for me to be here. I want to thank my Chief Judge for allowing me to come to share my thoughts with you, and also to thank BOSAN for this initiative and for the privilege of speaking on this podium. I do not take it for granted, and I take it with a lot of seriousness. May I also, as other speakers have done, congratulate the new silks about to be sworn in, and to adopt all the remarks made by the previous speakers as regards the responsibilities of your new rank. And I wish you all the best. I say the same prayer that Professor Nodeko said at the beginning of this program. My discussion will draw a lot from my experiences and from what I see on a daily basis in court, in the conduct of counsel, and in particular, senior counsel. So my topic of discussion is the Senior Advocate of Nigeria, a reportable presumption of excellence and scholarship. A view from the bench. Yes, it is reportable, but by the time I finish my discourse, you will see that that presumption is very, very strong, and is growing into a rule. Indeed, most of the senior advocates of Nigeria display distinction, they display excellence, and they display scholarship. Conduct of most of the senior advocates of Nigeria is impeccable. I have come across quite a number of senior advocates of Nigeria, and I know that without batting an eyelid, 90% of the senior advocates of Nigeria in this country are good material, and they deserve. Now, the rank is a privilege. It's a mark of distinction conferred on you by the Privileges Committee. That privilege can be withdrawn, and on occasion it has been withdrawn. So, and of course, many of you also know that there are a lot of people, quite a number of people, who are qualified to be senior advocates of Nigeria, even more qualified than many senior advocates of Nigeria who are not wearing the rank. So please consider yourself as ambassadors of the profession and know that quite a lot is expected from you, each and every one of you. Your task is unenviable.
It's a very difficult job, just like the job of a judge. And since I'm wearing the shoes of a judge today, I sympathize with you because it's not an easy thing to be a senior advocate of Nigeria. I have had more than my own fair interaction with senior advocates of Nigeria, and I want to say that one thing that sticks out for me is the requirement for senior advocates of Nigeria to be mentors, to mentor the junior ones. Now, the face of the office is changing. In days of yore, we had very old people. But of course, in the 80s, somebody broke the glass ceiling and became a senior advocate of Nigeria at the age of 37. We all know him, Shofude. Now we are having quite a number of young, energetic, upward-looking young people wearing the rank. Now is the time. Now is the test for this one. We see some exuberance, but in most cases we see the expected candor and civility. I've not really seen senior advocates show real hostility towards one another in court. But I had an experience very recently, which I'll talk about in this paper. But I spoke about mentorship, and I want to be a bit personal. I would avoid being emotional, but it is indeed an emotional period for me. I was mentored, and most of you know, by a gentleman called Otumba Jimi, senior advocate of Nigeria. Unfortunately, he passed on gradually in my arms on the 21st of October, and that was when I realized that having come into contact with him on a professional basis, he actually took me on and reviewed and made many aspects of my personal life better. It changed my work ethic. It changed my perspective of what law and law practice should be. Gentlemen, I'm in a period of mourning at this time, and I'm sure you'll understand. We are going to bid him farewell tomorrow. And but for the fact that this is a very crucial event, I probably would not have attended. So I don't know if I have the permission of the executive of BOSAN to ask you all to please stand up and observe a minute silence in honor of Otumba Jimi Otuba, senior advocate of Nigeria. And all the other faithful departed, rest in peace. Please sit down. So having done that, the virtues of hard work, fairness, and kindness came to the fore in my relationship with Otumba Jimi. He ensured that all his juniors were always ready for court, even if we were to go to take an adjournment. And I want to say something about taking an adjournment. One of my experiences with Otumba Jimi was to argue the case of Alpha at the Supreme Court. And we had a normal exchange. Like me and him would sit in front of each other and would argue the points. And he said, I'm going to the Supreme Court to get an adjournment. And I said, what are your reasons? He said, so. I said, they will not cancel an adjournment. So you better prepare your case. So he got there and started talking, I want an adjournment, I want this. Just simply just said, come. Mr. Otumba, you are arguing this case. So the case went on. And our plan B turned out to be right. Because in the course of the arguments, Justice Eagle asked the Solicitor General of the Federation the telling question. And the telling question was this: if somebody brings his vessel to Nigeria on your instruction, and he gets to the Lagos roads, and the Lagos port is congested, and you now tell him to go to Takoradi, is he going to bear that? Are you going to pay that? And the Solicitor General will speak. And because we were prepared for that eventuality, the case turned in our favor. There were concurrent findings of fact of the lower courts, the High Court, and the Court of Appeal against our position. But because we prepared for the case, we won the case at the Supreme Court. He did not hoard knowledge, and that is a fantastic library. I know that there's a lot of there are a lot of search engines now that may not make a big library full of books necessary. But I think it's still important for us to see those books. And I want to say, and quite a number of people refer to me as the Admiralty Judge in the Federal High Court. I want to say that I never studied Admiralty. And all what I know about shipping, I learned in Automatic Universe James. So when we talk about mentoring, you are being asked to practically change lives and improve the situation. And the task you have to carry on is like the task of parents. You are parenting younger lawyers, and you are ensuring that they do what is right at all times. I've had quite a lot being said this morning about lawyers being caught between and betwixt and not knowing what to do under certain circumstances. Of course, whatever the circumstances, look out for what is right, and then do that which is right. At the end of the day, it pays. Another thing about Otumba Dinoduba is that in appearance, he was impeccable. It took a lot of pain to dress and to make sure that he was properly dressed. His bands were snow white and starched. We, his products, when you see somebody like Femi Atoyebi, you see how he dresses. His bands are impeccable. And even if Atake is not his product, we can also see from that his bands are impeccable. And Guatemala here, impeccable bands. We see some bands and we want to borrow the bands for the day. But we see some bands and just wonder what happened. Did he pick it from under his skin? And senior advocates are not excluded from this practice. So you must be you must be impeccable in your appearance. And you must also dress properly as lawyers. You know, the way you dress is the way you be addressed. If a lawyer stands up in my court and I see that his bands are dirty, I just think that this man, what has he done? He's not even prepared. And younger lawyers will look at you and say, is this what this business is about? Lack of seriousness? But dressing is very, very particular, very, very important. So please make sure you dress properly. I've seen quite a lot of people in front of me here who know that they dress very well. Some who know that they don't dress so well. So, but that's fine. All this, your appearance and your candor and your personality, they all make up a person's personality. And that goes very far in commending one to others as examples. In law school, they told us something. Whatever the tribunal, your appearance is important. Dress properly, not study. Because as I said, the way you dress is the way you are dressed. Of course, mentoring also has to do with giving back to the society. Society that produced you and nurtured you, you must be ready also to assist that society in moving forward and ensuring that those coming behind you get the benefits of your own training. And we must all assist in improving the legal profession as an institution. It is also important for us at all times to maintain the best traditions of the bar. There are examples. One of the examples is here with us. Now I was doing this criminal case for 5 minutes. I've already so I have to, I'm sorry, but I mean, like, as you remember, I didn't start it with so, but this gentleman considered a point that was very much against his client's case, and the client got convicted. But when I saw a request from me to write a reference for him. Immediately, I wrote the reference. He's sitting down here on Tochukwu. This current gives me a lot of hope, and I've said your appearance, your brilliance, your capacity, robustness of practice, respect for the board and colleagues, which has been spoken about with other speakers, and mentorship of younger lawyers. Of course, you must be fair to the other side. So if you see that there's a point that is against you, you must concede it. But there was a gentleman who I was having a case against, and he walked up to me and said, look, I hear you want to get an adjournment. Look, this is the rule. If you ask for that adjournment, this case will be dismissed. And trust me, I asked for the adjournment, and on his application, the case was dismissed. So we must always try and assist one another. The rank is a privilege and not a right. And I did mention at the beginning that I'm going to refer to an incident that occurred in my court very, very recently. There was an application for an adjournment, very senior advocate, and there was an opposition to it by not so senior advocate. And I had listened to the reasons given for the application, and I had made up my mind that those reasons were not good enough. And this other lawyer was arguing. But then he went and made the wrong point and said, look, and also we don't adjourn this case for the examination because we don't want anybody to coach in this. And I said, no, you must not say that. Because that was an insult to other. And of course, because of that, and because there was a lot of heat from the other counsel, I said, well, this adjournment will be granted because there is also already heat in the courtroom. Most of what I have said, most of what I'm going to say has already been said by most of the speakers. But I have to touch on two things, the docket and technology. Now, our dockets are very full at the Federal High Court because when I was in Lawrence, Chief Alogu was there, I could have maybe 2 or 3 cases a day. All right? I'll get into court at 9 o'clock, right at 9:15. I knew all the channels on TV. But in Lagos, I am an administrative judge. As of yesterday, I have 1,010 cases in my court. The least busy of my colleagues has 1,300 cases. The most busy, the busiest has 1,650 cases. Now, how do we cope with that? How would you be impatient? And lawyers will come and say, take this case from this judge because he's not spending time on the case. He cannot spend time on the case because there are too many cases. It has a lot to do with our rule system. That's a lot to do with technology. It has a lot to do with ADR. And of course, I think this body, and I want to speak now, Charter Marriage Rules, I want to speak now. I want an initiative from the body of senior advocates of Nigeria to look at our rules and see the things we are doing wrong. We stopped changing our rules in 1963. 1974 Lagos State High Court rules, yes, but the Federal High Court rules are not up to the point. So the issue of cost, very, very important. And then talking about technology before I take my seat. The issue of presiding judges and the role of senior lawyers, technology before I take my seat. In the Federal High Court now, we have at least 7 courtrooms that are fitted with virtual hearing facilities. Now, I also want to say that our new court complex that is coming up is being fitted with state-of-the-art technology. We have an e-filing system, the agency is doing that is being rolled out. And that will, to a very large extent, assist in disposal of cases. I think I've spent my time. I want to thank you very much, and I also want to thank you for allowing me to at least give honor to whom honor is due. You are the salt of the world. If the salt in you is not salt, then how will the world be salted? You are the light of the world. If the light in you is dark, how dark is that darkness? Thank you very much.
Impressive presentation, which of course was leading with practical instances. Now, he raised the point just for ending about rules and regulations and why do we adhere to
rules and regulations that are not doing us well. Now, I don't know if you ever wonder that it appears that these are really self-inflicted. Those of us in this part of the world received not only in profession of law, even in our governance system, we received, developments and policies that evolved from experiences elsewhere over centuries, and we held on to them, tenaciously, as if they are rules from God. I've been asking the question, why do we have to go through an electoral process every 4 years? The expenditure it entails, and the fact that before the white man came, we had forms of governance in this part of the world. Why did we throw them all away? I was to interact with some students, undergraduates at the 300 level criminal law, sometime not too long ago. And I did a little bit of research on customary criminal law, on which there isn't much literature really. And one of the things I found was that it was the ease with which forebears, gave up what they had. The ease. They did not even challenge the white man or say, look, this is good for us. And here we are today. You tell me somebody who found in the marketplace killing another person is presumed innocent. Why should we presume him is the one we saw him killing? Look, we are lawyers. I know you may be wondering what I'm saying. But the truth is, in African criminal jurisprudence, that sort of person will be taken to the palace of the king, and before evening, he said, he will have been beheaded. And just this up. Well, because we've taken it so much, and we are not even questioning these things. On the contrary, we are digging down. I think we should look at some of these things over time and ask questions whether or not we need to hold on to them. That's just an aside. I'm not actually fascinated to have a session, but I'm sure Timola Akirele would have loads to say to stimulate your interest. It's my pleasure to welcome Mr. Timola Akirele, Senior Advocate of Nigeria, to talk on the relationship of senior advocates with older lawyers. Thank you.
My lords, distinguished panelists, organizers of the BOSAN, and distinguished learned friends, not brothers. I want to take you back, because as I stand here, I feel a sense of nostalgia, because most of us here have stood in your position. But I want to take you back to 1999. It was the eve of the millennium, when the decision was made to empower younger senior advocates. There were about 13 of us, but I think 8 were between the ages of 38 and 42, of which I was the youngest. It was pioneered by Justice Lewis and some progressives in the profession, and they felt the need to steer the profession and refresh it with younger lawyers. There was opposition, even petitions were written by some very senior lawyers who were eligible and even probably more eligible. But you find life is all about when your time has come, your time has come. And we came with, of course, a collective experience. All of us were trained. I personally was trained by Chief Rotimi Williams originally, who was the master of civil law. My father was the master of criminal law. You had Mofia Take and Joe Ajayi. You had Jimoh Lasisi with Harry Wagner. You had Ishonemo with Balikari and Ishonemo, Kola Oden. It was a collective experience of very high quality people. But we still felt the responsibility. And what we saw there, in a very subtle way, even though our seniors were still around, that there was a subtle transfer. And not sport, of course. In the 80s, they gave it to Mr. Shokuni in his 30s. And I think they also gave it to Latif Fagbemi when he was 27, 2 years before. But it was the first time they took a collection and an aggregation of a lot of lawyers. And what we saw then was, in a very subtle sense, a transfer of responsibility from one generation to the other. And I personally saw it even in a more dramatic way, in a manner in which a father decides to confer a legacy on a child. And what happens to that child is that you have what I call the burden of inheritance. And by that I mean that you see a conflict between the genius of the past and what your present aspiration is. And it raises questions as to what do you do with this legacy? And there are three choices. The first choice, of course, is to squander it, as some people do with legacies. The second is to maintain it. The third is to look at it and improve on it, and to a large extent even improve on it to the point where you will not even probably recognize your ancestor. And to understand this, I looked at the history of the profession. The generation of Chief Rotimi Williams, Ken Ishofola, and Fanikawe learned from the masters of the profession. People like Sapara Williams who heralded the profession, and then we had Kitoli Ajasa, Adetokunbo Madino Malakija, the Moore brothers, Sir Alex Taylor, who was known as the cock of the bar, the equivalent of Chief Rotimi Williams in those days. Those were the masters they learned from, and they were well taught. But there was a difference. They saw there that they were under colonial rule, so they had to navigate between the colonial oppression and looking for independence. So whilst the quality of law practice was extremely high, and they bequeathed to Chief Williams' generation a fine sense of learning, they were divided between politics and the law, and you find most of them were very much in the politics of the day. But by the time the generation moved to Chief Williams' generation, they were not hindered by the politics of the day because independence had arrived. And they found that how do we express ourselves with the legacy of our own ancestors? And you could see, of course, most of us are around to see that generation. And you could see the way they looked. Chief Williams decided to build a law practice that developed the indigenous law of this country in terms of the constitutional and civil law. Mr. Shokola did the same, J.K. Ajayi did the same. So the whole generation of them saw their own role. That once we are well trained by our ancestors, it is now our own time to bring this law and develop our indigenous law. And they have this illuminating reputation that resonated around the world. So by the time the burden was coming to our generation in the 1990s, we had to also decide what was it that we're going to do with this mandate. I personally took the view, you could not, of course, reenact the Chief Williams or Mr. Shofola or any of those individuals. But what I saw was that you could amalgamate all the qualities of these great advocates. And what we used to do in those days, we've been running from court to court. Even though I was a junior of Chief Williams, I would go to see Mr. Ladner cross-examining, I go to Mr. J.K. Ajayi's court, and I saw it. I saw in Chief Williams, I saw that insight and industry. And it worked somewhere in my system. I saw Mr. Ajayi, as Justice Fadi said, he was like Mr. Oduba, an emblem of neatness, most elegant in appearance and most elegant in oratory. You saw Mr. Ladner, who was ferocious whenever he was cross-examining. You saw GCM on UK, who was so majestic in presence. You saw Mr. Shofola, you could not afford to be walking around without dressing properly. You pull your tie and pull your jacket off. So we saw in all those qualities and you amalgamate it into the kind of person and the kind of advocates which you want, because you have that mission as a disciple of your own generation. And again, what we do better than they did? They didn't have the technology that we had, so we started. In those days, it was fax machines. They used to use telex. I remember working for Chief Williams, telexes would come from law firms and working for chance. It may take time to reply. So when the fax machine came, we took the view, you must reply immediately. And even if you didn't have an answer, send a response. We'll be replying to you in 2 days' time. So we learned from the foundation and we said, how do we build on this foundation? That was the way in which we solved it. Of course, there's arbitration that has come in our generation on a wide scale, which puts us at a very, very high level where your advocacy skills are competing with the best in the world. I did a recent arbitration in UK with foreign QC arbitrators. And coming from Nigeria, you needed to show them as an ambassador of who you were. And as the arbitration was starting, it was a joint venture dispute. I needed to catch their attention. And I said to them, Leo Tolstoy's book written called Anna Karenina Stars. All happy marriages are the same, but all unhappy marriages are different in their own particular way. The story of this dispute by the joint venture partners is to find out why this unhappy marriage was unhappy. Immediately, the arbitrators listened. Again, this goes to the notion of knowledge. You must continue to read. Read widely beyond the law. Have expressions that will capture attention because you are an ambassador of the country that you represent. Now, looking at what this means to us, this second our generation, individually, coming in at 38 as a senior advocate, when you still had a lot of seniors who were very good and better than us in practice, you had to have humility. The first appearance I had was before the judge in the High Court of Lagos. And as I sat down, normally you have the rights of witness. But he didn't call my case. Case number 1, case number 2, case number 3. But I kept calm. People were tugging me at the back. No, you must mention your case. But I could understand the psychology of the judge. As a new young advocate, let me test who he was. I didn't want to get to it. The emotions, you must always have your mind in control. You have your client's case. I wasn't going to upset the judge. I knew what he was doing. I was patient. When he got tired, he called me and asked me for my case. And as I told my juniors, the convenience is the convenience of the court. It's a privilege you have to mention your case. But it's subject to the court's convenience. Even though in this case, the court may have stretched the convenience. But notwithstanding, I concentrated. And subsequently, the judge met with me later on in a social function and was able to laugh at the gesture. Whereas you could have had another reaction where you feel arrogance and you stand up and you feel, my Lord, my case is to be mentioned. So sometimes discretion is the better part of that. The second one was appearing in the court of appeal, where Mr. Fuji Braithwaite, who was one of my mentors, when I came back home, he gave me a few cases, and I could not bear the idea that I would mention my case ahead of him. So I told him, just a good idea was beside me, that, my Lord, may I have the permission to waive my appearance, my preemptive appearance, in favor of Mr. Fuji Braithwaite. I said, am I sure? I said, yes, I'm sure. Now, I didn't have to do that. And again, it's a privilege and it's subject to convenience of the court, but the judge granted the convenience. So you have to come with that clarity of mind that no matter what you've achieved, the humility of your condition is absolutely critical in dealing with these matters. So that really is a very, very important, very, very important element of the comportment of this life. The second one, of course, how do you deal with lawyers? I remember appearing against Professor Lawan, an excellent man, Professor Lawan, very fatherly, and we had this very passionate, very heated case in which I pressed my case with no news. And when I finished, I went immediately to him to extend my regards to him. And being a gentleman, we had a good laugh. And he teased me, oh, I thought you were a very quiet man. He just exploded. But it was not a duel between us. It's a duel between my clients. You are being paid on behalf of clients to use your skill and voice to propound on their behalf. But it's not your duel, and it's not your case. I also had the privilege of cross-examining late Justice Kayode Shaw after he retired in an arbitration, where he was an expert witness, and I was able to go through all his cases on the subject to see the contradictions. And how do you handle taking a man like Justice Kayode Shaw and cross-examining him in an international arbitration without almost feeling a sense of intimidation or even offending the judicial dignity of which he represented, even that generation of judges? But I had to be very calm, I was very gentle with him, taking him through, even almost explaining to him that perhaps he had changed his mind over the years. And by the time I finished the arbitration, he came to me and thanked me for the kindness in the manner in which I treated him. So these are very, very important elements you must have regards to. Another incident I believe I had was with Chukwuemeka Chukwura in a case called Omena and Spasu. This was just before I became senior advocate, and I learned a lot from it. He didn't expect me. I think the point was mentioned by Joseph Fajo, no idea about him. Always prepare. He thought, oh, this is a young junior. I adopted his brief, and I reacted with a lot of vigor. And at the end of the case, it was obvious where the decision was going to go. So he called me, and I thought he was going to call me to reprimand me. I said, I can't really come. And I was walking towards him, just stop. And then he bowed his head, and I bowed my head back. And you know what I've done? I did it to a junior in the Federal High Court who performed so superbly in terms of the superiority of his argument, so that we must continue to transfer this technology of courtesy, because what you do is that you inspire a generation of lawyers. There might be moments of tension. I saw with Chief Williams that he was a master of wits, for example. There was a time Mr. Iwalaja was arguing at length, and the judges, and he apologized to the judge. I'm sorry I've gone on for so long, but I had to give Chief Williams food for thought. Chief Williams smiled and said, my Lord, after 1 p.m., I was having thoughts of food. The whole situation was yesterday. You had it, Mr. Here and Mr. Shokola were constantly at war with each other. And when Mr. Shokola has gone on, Mr. Williams will start off, my Lord, I'll be as long as Mr. Shokola is short. And then again, tremendous humor. So sometimes you need your humor, you need your charm. Your learned friends are your friends, whether they're juniors or who you are, you must continue. You must continue to charm them, because At the end of the day, it is the spirit of the profession. Now, to your generation, the challenge you have, the most important thing, because I said every generation must recognize what the issue is that we have an ethical challenge. The profession is under siege. The public are holding the profession, particularly the judiciary, in low esteem. But again, that is an error, which I want to point out. That I find that lawyers have no business criticizing their own profession and running it down on social groups, in the newspapers, in international fora. It's like running down your currency. It's like going out and you have a family, your wife and children, and telling outside how terrible your family situation is. It's self-defeating. We have a problem. I remember in Shakespeare's Romeo and Juliet, that two families were fighting the family of Romeo and Juliet. And they were trying to work out who was to pay. And Shakespeare, through the voice of Mercury, said, there's a plague in both the houses. There's a plague in both the houses. There's no difference between the judiciary and the lawyers. If we have a problem, then it's an internal matter that requires resolution. But it's not going outside, because people just laugh at you. But if you can't resolve your matters. And the question is, what do you do? And I always say, at the very basic level, Lord Hillsham put it this way, he said, the reputation of a lawyer is what his own colleagues think of. And I can go further, it's also a genius think of. Because they see you every day, they see your secrets. What do you do in your chambers? How do you influence your juniors? Are they ambassadors of the profession? Do they carry the ethics? Can they see from your behavior? Because they are the next generation who you're going to mentor. You're a transmitter. I remember reading a book on philosophy where one man was accused of knowing so much of the Greek philosopher Homer. I said, no, I don't know so much of him. I've only read. Homer started, or Socrates was influenced by Homer. It was like a magnet. Then the magnet of Socrates affected Plato. Then it affected Aristotle. So that there is a transmission of learning. And if I look at my own personal evolution, Sigismund Moore, who's my mother's father, my grandfather, was a master to Chifrotimi Williams when he did his pupillage in Abeokuta. Chifrotimi Williams, my father, when he came back from abroad, and there was Thomas Williams and Banika, he tutored like Chifrotimi Williams. I tutored on there. So there is a transmission. And that duty makes it important that I transmit to my own juniors in my own office so that when they go outside, they have the choice. Because not everybody always accepts the magnet. So you must continue to have that magnet in a continuous manner. In that way, the profession is enriched, your colleagues are enriched. The final point I want to make is success. Now, we have the right to be doing it, no matter how successful we think we are. And success is a very dangerous thing because you tend to think you are at the top of the world, but you are not. Because inherent in success is a potential for adversity, because your caution becomes less. Inertia may creep in, don't work as hard as you did. The struggle that brought you to become senior advocates becomes less. And with that, temptations come, mistakes come, and errors come. And you will find that it is that alertness and the relationship you have with your fellow colleagues that keeps you on step. You'll be surprised that when you create that reputation, there's a presumption of trust always. There's a huge potential fraudulent matter between a financial institution and a borrower, where we found that the borrower colluding with someone in the institution had even used the name of the firm to have prepared the documents, because maybe many years ago I prepared a specimen document for the institution. So they just manipulated. But because the lawyer could not believe it, he came to us and said, something has occurred here, and I knew it cannot be true. And through that, the investigation was done and to clear matters. Now, that is your colleague helping you from outside. The colleague may not necessarily be in practice, it may be in government, but because of your reputation, it always gives you a presumption of trust. So always be very careful. There will be risks that will come that you will know even from the amount. People, any amount, as my father says, that someone will ask, there must be something going down, something going down at anything. You take it away. Because you find in life that money is always very attractive, but when the trouble comes, regret is stronger than desire. And you will pay everything that you have done and more to get out of the situation. So that alertness is critical. And again, it is the relationship you form and the reputation you build that continues. And another note, which is not necessarily directly related to my paper, but I try to pass it on to colleagues, is We're all going to get old. I watched a documentary, Animal Kingdom, and I saw a lion looking so old and wicked, couldn't hunt anymore. One day you're not able to hunt anymore. Your plans are going to be junior lawyers. So the question is, what are you doing about it at the peak of your career? Which means you need to invest. Find a vehicle that you are able to put your funds when you're at your peak that will create a revenue for you as you get older. In which case you'll be still able to maintain your dignity. So I welcome you as senior advocates of Nigeria. It's a huge, huge responsibility, but if you recall the history, and always go back to the history of the profession and realize that you are the ones now with this crisis going on that can carry this thing and ensure that this profession is sustained, because the children will ask what happened. That is the burden of your own inheritance. Thank you very much.
Thank you very much, Mr. Kirele, for that presentation, which took us through lots of the flavor of our profession, from the origins to the forebears of the profession, and even to the issue of mentorship, which we emphasize, which I think should by now, it's been said by a number of person put us today, and I have no doubt that you are paying attention to that. We also acknowledge that we should prepare for the days we will become the old lion, and so that you have those who will sustain your quintessential lifestyle. Thank you very much for that. We've been told that lunch is for 1:30, and we'll try and get through so that we can get back on schedule. We are really back on schedule now. And if there are questions, which I believe there will be, yes, as we did in the first session, the two from here, none, yeah. What about the third?
Balogun. My remarks or question goes to my lord. This is Wadi and the other, and my lord too. Spoke about the issue of judges and lawyers to interact. And I want to say that I agree. As a bad person, we used to have judges, lawyers forum always, but I don't think there's any effect on that. I'm worried that a judge will think they will stand at the Olympia heights. They want to think, oh, they are overlords. I am worried. I've read the case of Minekaya and Minekaya, in which the Supreme Court, a judge record lampooned, I think, let's say, is it, oh my God. I've forgotten now. Thank you very much. Supreme Court now says, no. He said, we are like siamese twins. And he said, we respect, the guest respect. It's reciprocal. So that is why if judges are having a conference or conferences, I want to emphasize that they should always know that we are together. They should not dress us down. Sit down. Who are you? No. I'm worried on that. Number two, on the rules of court, that is worrying my lord. The Supreme Court are also having decisions are conflicting. Most of them will say it must be obeyed. Even when that not serve justice. Why? Some will say no. Like Begore. Yes, as there was. He said the court must not be slavish to the rules. The court must be master of the rules. Now the judges are using it to say, no, my lord, please, stop. Rules of this my rules, is my court. I must obey it. Why can't the court now say that you don't be slavish to the rules? To serve justice. I thank you very much.
My lords, seniors, distinguished ladies and gentlemen. Let me say first of all that I consider it a very great privilege to be here. and I'm grateful to God that most of us have made it this far. I have three comments. The first one to my Lord in terms of the interaction between the lawyers and the bench. One major challenge that we continue to have is the issue of how to manage the docket of the courts a lot better. And some of us who are very ADR centric have many times tried to suggest to my lords sometimes ways that we could help move the case forward. The challenge that we get, and my Lord Justice Faji, I remember, I think in May or June this year, we were together at the Federal Palace, Sheraton Hotel. I don't know if you remember. For the, nothing untoward, my Lord. We were there for the, I think it was there was a seminar on the national policy on arbitration and ADR. And we're out there to contribute. And the major challenge is that we have so many judges who still need to be educated about how we can incorporate ADR. And it will help if my lords can pass this message to their colleagues, because there are times when you make a case before my lords to say, this case is suitable for ADR, and the impression that is given is that you are not ready to go on with your case, or that you are either ill-prepared or that you do not have a strong case. So I want to respectfully suggest that maybe this is one of the things we can take away from here. On the issue of as by my learned Silk speaking on the issue of relationship between the senior advocates and other colleagues, I want to speak particularly on the issue of the courtesy that learned seniors must, especially as senior advocates, must advance to our colleagues. And I'm grateful to you, sir, for the way that you presented it. Because I remember doing a particular case 2 years ago where I had on the other side 3 distinguished senior advocates of Nigeria. And their case was a bad case, if I may say so, with every sense of responsibility. And unfortunately, in the heat of the argument, one of the very senior advocates of Nigeria said to me, "You do not have anything to say, please sit down." I do not know how we can imbue in ourselves a bit more culture of that reciprocity. Because thank God for my own disposition, I'm not the kind of person who would ever be aggressive. And then I took it in my stride, I smiled and I said, "Sir, I will sit down, but you know that the right to stand up and advance my case is one that I always have." And so I sat down and then got up and continued. And now, someone else, and I've witnessed that, I've witnessed a spark between a young lawyer and a distinguished senior advocate of Nigeria. And I think it's important that we continue to underscore the fact that we must treat our colleagues with respect and with courtesy. And as you rightly said, and I think the greatest thing I heard from you this morning is the fact that we must pay tribute to counsel when counsel demonstrates that they've even performed better than we have. And it's something that I'm going to take away from what you said this morning. My final contribution borders on the issue of what is the limit of advocacy. Many years ago, particularly in 2008, following the 2007 elections, we were before the Court of Appeal in Jos, and a very, very distinguished senior advocate of Nigeria made the day before an argument. I won't, because there are so many of us who are practicing here, I won't say what it is in case I point to that in a particular direction. But he made an argument for a particular position. And the next they made an argument contrary to that position. And I recall that my Lord, Justice, I think it was Justice, former President of the Court of Appeal, my Lord Justice Booker Chua, yes. My Lord Justice Booker Chua said to him, "Learned senior advocate of Nigeria, we have here very young colleagues. Which one do you want them to accept? What you said yesterday or what you said today?" And he said, "My Lord, I'm doing the case on behalf of my client." The point I'm trying to underscore, sir, is I think it's important that we, as senior advocates, I do not know what internal mechanism we have here of peer review that can help checkmate those kind of things, because it actually, apart from the fact that it makes you look bad, I think that it has a way of rubbing off on the institution and indeed on the rank when people see that you are inconsistent. And of course, there is a policy that one that affects one individual affects all of us. That's my humble contribution. I thank you, sir.
Kennedy, I know. Permit me first and foremost to quickly recognize my teacher that I have not seen in almost 30 years, Professor Yemisi Bambushe, SAN, told me through my role. I want to thank you very much for your teaching, for the sheer candor and your sheer dedication to the duty. I really appreciate that so very much. It's a real pleasure to see you again today after so very many years. I must say that I'm a little bit confused. Now let me explain a bit of my confusion. One is that there is a sense I get as it relates to the responsibility of the incoming senior advocates of Nigeria in their individual capacities. And I'm left asking myself the question, given the point raised by Osaro yesterday, which was also at the same time I get up on by demoralizing as to the fact of the state of the nation right now, particularly our profession, how broken it is, and the extent of the damage that needs to be fixed in that regard. And the question for me is, what really is the role of BOSAN? What is BOSAN, what does it stand for, and what can BOSAN do? As individuals, each of these SCNs in their own right, they can do so much, but not much more than BOSAN can do. It would seem to me that the power that is resident within a body such as BOSAN is not well understood, is not well articulated in such a way that some level of difference can be made in order to address the systemic challenges that we have in our profession today. And I think it's important, I believe, that BOSAN should rise up to that responsibility. And I went into looking at the objective of BOSAN. And what it says here is that the main objective is to advocate for leadership. And I think that it's important that we rethink that very essence and that very objective and start to think what we can do as a collective body in order to bring about the change that we need today. And I think it's also important to identify the point raised by Demola SCN in terms of the sheer level of decadence we have, which is the fact that the entire culture is broken and it doesn't exist anymore. When he went down memory lane and he made reference to a number of interesting people of those days, the truth and the reality is that they don't make them like that anymore. They just don't. The culture is completely eroded. It doesn't exist. I have been in the Supreme Court a number of occasions in which I have listened to the justices dress down senior advocates of Nigeria. In the 70s, it was such an embarrassment for me. And I asked myself the question, so what does this represent? Why do I want to become a senior advocate? Now, is BOSAN aware of this and what are we doing about it? At the same time, in the course of this pursuit for SCN, I've also been to Abuja a number of times, in which I'm in the High Court, and I'm told that the court is not sitting. Why? Because the judge is attending a conference, because the judge went for a dental appointment, and we watch all of this. Now, every institution or everybody, be it even the hall, there must be a culture that defines that. What is the culture we think should define our profession? And I think we should find a way to define that. Thank you very much.
From the floor. I believe there are two very important issues. And if these two issues are addressed, we might be talking of a glorious day and bringing back the glorious day of the past once again. One is leadership. The character of any organization is determined by the character of the leadership. Most of the things that the leadership can do to change the face of legal practice, we have not done them. And the essence of leadership is to solve problems, is to accept responsibilities, is to identify problems and confront them. No problem is ever solved by technically avoiding it. What we have been doing in this profession and by extension, even to the country at large, is to be avoiding our problems. We always think that, oh, over a period of time, the problem will solve itself. So leadership. By the time the issue of remuneration of judges and justices came up, I think last year, so there is no adequate enforcement of our rules of practice. The code of conduct are obeyed in the breach. My Lord Honorable Justice Fadi said that a single judge has 1,600 cases on his docket. How many hours do they have per day to work? But we are the ones taking the cases there. And some of these cases are also perpetrated, they are instituted by seniors. And that is why I am praying that a new generation of leaders will emerge in this profession. Now, I give you just 2 examples. A Supreme Court has given a decision, and somebody comes back to you in chambers to say, I want you to go to the Supreme Court for me to reveal the decision of that court. And you take it. You go to the Supreme Court. At the end of the day, you lost it. You have crowded the docket of the Supreme Court on that. Now, an award is brought to you. A matter has gone before arbitration. A commercial dispute has been settled by arbitration and an award rendered. In Nigeria today, for most of the senior lawyers, arbitral award is becoming a cause of action. Rather than solving the problem, it's becoming a cause of action. People will take it to the High Court, from High Court to Court of Appeal to the Supreme Court. Even where the decision of the High Court and the Court of Appeal are concurrent decisions, they will still go to the Supreme Court. Things like that should be avoided. We must get to a point where we can advise clients. This, you don't need to go to court. This thing looks like gold, but it's a mere stone. It's not a gold. So if we reduce frivolous litigations, it may lead to some loss of income, but please, by the time the client is leaving you, you would have learned 1 or 2 things. So, please, the focus is on the body of senior advocates of Nigeria and the senior advocates now to reshape the destiny of practice. I think the larger body, maybe because of population or one reason or the other, we are not as practical or proactive as we should be. Life is a practical entity. Unless you address it practically, you don't get to where you're going. Thank you.
Of the bar and the bench. We should not give up. There should be greater interaction. So much so, in fact, that where lawyers are doing things, there should be judges. Where judges are doing things, there should be lawyers. Let us come to a more practical aspect. Judges themselves as individuals have different temperaments. Therefore, there should be understanding of each other. I do recall that before I became presiding justice in Calabar, I sat with one judge, one justice, who later went to the Supreme Court, and the common reputation that surrounded him was that he was bad-tempered. He was the type that would say, sit down. And from the bench, we had to correct him, because he gave us the burden of having to appeal to the Bar Association on one occasion. We had to go and beg the lawyers that, oh, this is not tolerable. Well, I think he changed, he's now retired from the Supreme Court, and so on and so forth. But even as lawyers, we must understand that as individuals, we are not the same. But I think for each person, we should have understanding. If a judge is seemingly rude to you, you don't resort and then be rude to him. Because you have part of your own duty is to protect that aspect of the profession. That is the way I see it. Rules of course is by Mr. Balago again talking about rules of course being obeyed.
or not being slaves to the rule. That will depend on circumstances. I mean, there are decisions that have said rules of course must be obeyed. But when rules of course are just mere technicalities, you will not be a slave to it. Definitely. Definitely. Dockets of course and ADR. No, there's no doubt that mechanism of ADR is getting more popular. I do recall I was the chairman of the ADR committee for the Court of Appeal, and we made ADR rules. And I think there are standing members of the court in Abuja and Lagos now that actually deal with ADR matters that are referred by the Court of Appeal in Abuja, and I think Port Harcourt also. Someone was saying, for responsibility of BOSAN. That was a comment by this side now. I think I'll stop there.
It's also very important that we must all change our attitude towards education. The rules are there, but of course, as you said, there are many rules, many schools of thought. Some say rigid adherence, some say it's just handmade in dispensation of justice. Now, in our federal court rules, we also have the AGR procedural rules, and in Abuja, we have an AGR center. The only reason why we don't have a center yet in Lagos is because of accommodation. But I'm sure that by the time our new complex is up, we'll be able to have some accommodation for that. But many of us also urge lawyers to go to AGR. Thank you very much.
Just on the point the gentleman mentioned about the senior shutting him down, that is always insecurity. The intellectual argument, someone shuts one down. So you must stand your ground with politeness and firmness. Those are idiosyncrasies which you ignore. On the question of inconsistency is an ethical issue, but there's an exception. If circumstances change, you can take a different position. And I'll give you an example. There's a saying by John Maynard Keynes, so John Keynes' economist, when they asked, he took a position for religion he had taken before, and he said, if circumstances change, I change my mind. What do you do, sir? So when there's superior arguments, better research, better facts, and even in those days, we saw in the arguments of Chief Williams, Shofola, and GOK, where positions were taken in different cases and were different to what they're taking in Bible. There were articulated reasons why those positions occurred. And the comment made by my learned friend about the rudeness of judges to counsel. And I've also seen rudeness of counsel to judges. And this is really where the whole thing becomes a vicious circle. And I was in a case recently where a senior advocate threatening to report a judge to the NDC because he was giving a ruling because he has entered an appeal. The ruling was ready on the day and he just entered the appeal hours just before the ruling to arrest the ruling. And threatening, literally, no problem. So these are the problems. So respect begets respect. But as my Lord said, you have to use your discretion when you're provoked. I remember in an English case called Hungry but Home Office, where Lord Denning, the Attorney General there, Mr. Sam Silkin, threatened Lord Denning and said if he intervened in a matter which had to do with executive privilege, it would not be long before the authority of the court would be called into question. And Lord Denning simply said, I've heard the observations of the Learned Attorney General. I don't think it was really serious on what he meant. I think it's just a mere piece of advocate's license. So you see, there was a very mature way of dismissing it, not allowing it to aggravate, because small matters can aggravate unnecessarily. More serious matters become circular matters, of course, report to disciplinary committees and content, but you have to use your discretion. But that is a human problem of the degradation of the profession where either a judge or a counsel get to a level where you're addressing them, because what you don't understand is that you're actually undermining yourself and the profession. And these are, again, the point you're making about the relevance of BOSAN, bodies which were part of the GRP, pressure groups. There has to be some kind of fora where this, there's an organized way where these matters can be taken up. But they will happen, and discretion, as I said, and wisdom must always be used to apply, must always be applied so that you don't have the situation is getting into hand. So those are my observations to the three comments that related to my portion of the speech.
Justice Olayinka Faji, the Admin Judge, FHC, Lagos, and Mr. Adimola Akinrele, Senior Advocate of Nigeria. Thank you very much for your contribution. We will now adjourn for lunch, which will be served you'll be overlooking the 5 cowrie case. And again, raise especially those who are from landlocked places. They can share a bit of what is in your deal today in Lagos. We'll have one
To the third session, post-lunch. This session will touch on accountability and discipline of senior advocates of Nigeria. I would like to humbly request that we put away devices of mass distraction. They're called WhatsApp, email, WhatsApp, text messages. This program should ideally stretch to 3 days, but because of the challenges of time and in order to allow you to get back and prepare for next week, we've sort of put it on a crash to 1 day. So we would be requesting your full attention. The program is still on, and I'm now going to invite respectfully, yours is a panel of 3. The first panelist is a very distinguished learned senior advocate of Nigeria, Mr. Louis Mbanefo, SAN, please. Distinguished Silk will be talking about the duty of senior advocates to the society. Next, to talk about professional misconduct and discipline of senior advocates of Nigeria is himself the author of the book Contempt of Court. And there's so much you need to learn from Dr. Eyimofe Atake, SAN. Let me again invite the full attention of participants to be with us, body, mind, and all attention. To discuss accountability, discipline, leadership, and regulation of senior advocates of Nigeria is Deacon Dele Adeshina, SAN. Today we talk about written and oral advocacy. All your arguments today will be in writing. So advocacy through research, and thorough research if I may add. Thoughts on it will be shared by Professor Oluyemisi Bangoshe, SAN. Panelists have 20 minutes each to share their thoughts, and there'll be a Q&A at the last 30 minutes. The whole thing will last an hour, 30 minutes. Please begin.
There was no hurdle. You just filled in a form, and they did the rest. But I understand that these days you have to go through the mill. So I congratulate you all. What I'd like to focus on is the origins of this senior advocacy. We learned it from the British. They had their Queen's Council, something that goes back centuries. And in 1975, it was Justice Fatai Williams who decided to introduce it, Professor CJ, to Nigeria. And began by appointing 2 very eminent lawyers, Chief Rotimi Williams and Sir Graham Douglas, as senior advocates. Since then, we have gone through a lot. And what it entailed all those years ago and what happens today are very far apart. And what I'd like to do is to go back to the basics. And in Hall was circuit messes. They lived their professional lives under the constant scrutiny of fellow members of their own profession. It is not surprising that these pressures produce a high degree of conformity in response to what is considered good form. A barrister wears a uniform. He calls other barristers by surname rather than as Mr. He generally does not criticize the bar or its institutions. He conducts himself honorably in court and in his dealings with his opponents. One applies for silk normally for one or more of three reasons. One, to escape the crushing load of a successful junior practice. Two, to earn more money. And three, to take the next step towards judicial preferment. Well, I'd like to stop there and focus on those three reasons why people in the UK applied for silk. The first was to escape the crushing load of a successful junior practice. In England, as a barrister, you're on your own. You're part of a chambers, but you're on your own. And if you sit down doing nothing, you'll earn nothing. So you are briefed as an individual, and the more successful you are, the heavier your workload. So by the time one has practiced for 20 years or more, people look forward to taking silk so their workload reduces. Because as a silk, you lead the juniors do the hard work, but you do the ultimate leadership. So people take silk in order to lessen their workload. It's a risk because sometimes their workload is greatly diminished because as a leader, they're not so much in demand as they were as juniors. So the second one, to earn more money. Well, I'm sure that is familiar to all of you. If anybody says he doesn't want to earn more money as a silk, he's not telling the truth. But to earn that more money, there's heavier responsibility. You're expected to maintain the ethics of the profession to a very high degree. The third is to take the next step towards judicial preferment. See, in the English system, practically every High Court judge has been a silk before being appointed to the bench. And in Nigeria, if you ask the average young lawyer, what is your aspiration? Do you want to be a silk or do you want to be a judge? They'll invariably say they want to be a judge. Sorry, to be a silk. And unfortunately, that has greatly impinged on the quality of our judiciary. Because the best lawyers, with due respect, of course, to some of the eminent judges, the best lawyers opt to take silk rather than go on the bench. I would have recommended, if I had a say in the matter, that everybody who becomes a senior advocate should undertake that after a certain number of years, you go on the bench. You'll not go down well in Nigeria. You'll not go down well in Nigeria, but if you made that a condition, people will still apply to take silk, but they'll be mindful of the fact that at a certain stage, they have to go upstairs and do substantial justice. So that is the problem that we have in this country. The other thing I'll mention is that the institute of eating dinners, which we practice here, is something that we learned from the British. Every young lawyer has to eat a certain number of dinners. I think about 36 altogether before he can be called to the bar. And it's not just a question of enjoying the gastronomic delights of the Inns of Court. That is the way that people in the old days learned their law. Because at the end of the dinner, they put the tables around and the chairs around, and the senior member of the bar would come and hold forth on some abstruse topic. And that is how young lawyers learned. But in later years, it became more of an institution where the young barrister felt as if he belonged to a profession. Because in the dinner, at the end of the dinners, the benchers, senior lawyers will circulate and introduce themselves to the young lawyers. And it's a thing of tremendous joy when you really kiss the Bordening, for example. And at the end of the dinner, he comes to you and says, young man, what are you doing? And you carry a dialogue with him. And you have the audacity to tell him, my lord, I disagree with your decision in the High Trees case. And you raise an eyebrow and say, oh, why? And then you start giving some reasons. And then he will argue with you to some extent. So in that way, you are exposed to the institution. You feel that you matter and that you're able to rub shoulders with the high and mighty. When we started the eating of dinners here in Nigeria, it became not just a ceremonial thing. And I think the benchers keep their distance, the lawyers keep their distance. And part of it, of course, is due to the fact that if you, as a bencher, mingle with the young lawyers, they will try to exploit the situation by trying to gain some sort of favors from you. They want to join your chambers or whatever it is. So many people tend to avoid that kind of interaction. So the institutions they have in England are somewhat different from our own. But nevertheless, we have to somehow fashion a system that is workable. And it's absolutely essential that we abide by the ultimate principles of the practice of law. Justice Ofuta, in his book, Modern Bar Advocacy, stated the various points that the advocate should consider. He says, the advocate's duty to his client is paramount, the advocate's duty to the community, the advocate's duty to the court, the advocate's duty to his colleagues, dress and comportment in court, seriousness in court, the need for cooperation between bar and bench. So those are the essential matters that the advocate has to consider. In particular, I would like to focus on the advocate's duty to the court. Those of us who did our pupillage in England, something of the majesty of the law rubbed off on us. And to argue with a judge, to bandy words with a judge, is not in our DNA. But here in Nigeria, it's become the norm. People write petitions against judges. People argue with judges in court. Some lawyers get press conferences at the end of a case in which they criticize the judge, criticize the judgment. All that is far removed from the real ethics of the profession. And I would urge all of you to please desist from that practice. I know that in many instances there's contempt for the judges because of the way they are appointed or their degree of skill, understanding of the law and so on. And it can be very, very frustrating. But nevertheless, it is not the individual, it is the office of judge that is important. And you have to respect that office. And I heard that when judges get together, they will talk about maintaining the dignity of that office in such a way that they earn the respect of the advocates and the legal profession as a whole. The other thing that is very important is dress and comportment in court. In these days, one sees all kinds of things. The most guilty are perhaps the lady advocates who come in all kinds of fashions, fancy hairdos, fancy outfits. All that is not within the profession. A lawyer should dress very conservative, very, very conservative. I remember many years ago in the 1970s, there was a hearing before Justice Anyebunam, and by mistake I put on a blazer when I was going to court, and the blazer had some brass buttons. Yes. And as I stood up, the first thing that Anyebunam saw was the brass buttons. He said, Mr. Anthony, if I don't listen to counsel with brass buttons in their jackets. So we have to be very mindful of our comportment, the way we dress, the way we address the court, and the way we show ourselves to society as people who live according to a certain code and certain standards of behavior. Then I will say something about the duty to the community. We live in a community where the standing of lawyers has somewhat diminished. In the old days, lawyers were like something almost divine, and they were held in very, very high esteem. But now, because of the large numbers of people coming to the profession, and the fact that we tend to regard everybody as qualified as a man of integrity, it's an assumption, a rebuttable presumption, but that is the presumption that is put forward. So we have to somehow improve our image to the community. And we have to go back to the old system of strict adherence to principles. I remember the late Justice Ede Farasin was telling us that as a young lawyer, he was representing a community in a case. His opponent was the late Justice G.B.A. Coker. And on the morning of the case was due to be heard, his car would not start. So he had to hop on a bus. And unfortunately, on the same bus was the chief and the members of the community. And he saw they were looking at him in a very sour manner. And the case did not go on. But when he got back to chambers, he was told that he'd be relieved of his brief and he'd be given to Mr. G.B.A. Coker. Because as far as they were concerned, a lawyer should not bring himself down to riding in a bus. There's a certain perception that the community has of the status of the lawyer, and that does not include riding on a bus. So, your duty to the community, as I keep stressing, is to maintain your dignity. And also, always believe that your integrity is paramount. In the English system, when a lawyer is crooked or falls out of line, everybody knows, because it's like a closed shop. The Inns of Court, I don't know if many of you have been there, it's like a college where they interact on a daily basis. And a lawyer quickly acquires a reputation for either as a man of integrity or as a man with slight shadiness in his character. So there is that sanction which the community of lawyers imposes on the body as a whole. And unfortunately in Nigeria, we don't have that same sense of community, because anybody can set up chambers anywhere and practice anywhere. So these are things that we have to look into. How do we create this sense of community where every lawyer is his brother's keeper, and we all try to maintain the integrity of the profession? Well, I don't know how I'm doing for time. I think my 20 minutes must be up.
Yes, thank you, Lady Silk. I was in trepidation to interrupt you. And I would disclose the reasons, but maybe you can wrap up in 2 minutes, that would be fine.
That's fine. Thank you very much. Well, as I said, I think basically the problem that we have in the legal profession is the problem we have in Nigeria as a whole, where truth has become negotiable. And if we are to go back to the basic principles. We are going to have to reform our way of thinking. There's now a way of thinking that pervades the Nigerian society. And the leadership has to come from somewhere. It has to come from you, the senior advocates. You have to somehow persuade the rest of society that integrity matters, that truth matters, that justice matters. And in your new role as senior advocates, I wish you well, and I wish you a very satisfactory and distinguished career as senior advocates. Thank you.
And the last but not the least, my father, Dr. Ajubu SAM. So I was in trepidation to interrupt the learning self.
So let us add that my wife was also in the group.
Yes.
We got married the same year that we were called to the bar, and we just celebrated our 50th wedding anniversary.
I should add that Zelena Silk was admitted to the English bar a year earlier, 1972. So 51 years in the bar.
68.
68. Apologies. Okay, so you would permit me to invite Dr. Eyimofe Atake SAN to come in with his perspectives, misconduct and discipline.
Takes planning, focus, hard work, and God's grace. And I think all of you, apart from meeting the criteria, have fulfilled the criteria that I have identified. So permit me to join everybody to congratulate you most heartily on this preferment. And I wish you every success.
Thank you, sir.
The legal profession is known as one of the most noble professions. Since 1675, 3 professions were identified: divinity, medicine, and law. You are part of what is a noble profession, or used to be a noble profession. Because its standards seemed to have dropped so seriously. I remember when I was a junior in the chambers of Chief G.O.K. Ajayi, senior advocates of Nigeria were viewed with awe when they were in a particular place. We young lawyers did not go there. But what has happened? That the profession is where we find it now. It's a question. I must add that in 1988, when Mr. Lulu Banifo was sworn in, I found in the old Supreme Court in Lagos, I found inspiration. And I went there to view. Why did I go there? It was the first time a son of a judge had been appointed as a senior advocate of Nigeria. And I wanted to see for myself and see what has happened and to inspire myself. The next person that became a senior advocate of Nigeria was Mr. Abakoba in 1988, the second son of a judge. In 1999, a year after, I became the senior advocate of Nigeria, the son of a judge. And I often say, I am the first senior advocate of Nigeria of a living judge. Because Sir Lulu Banifo had passed on when Mr. Lulu Banifo became a senior advocate of Nigeria. You know, I worked with Chief Joke Ajayi, and he did something. He said to me, I want you to come into my office to work with me. I want you to share an office with me. I was surprised. I was taken aback. I shared an office with Chief Ajayi, and we used to exchange ideas. In my respectful opinion, if you knew the man, that is how the manner in which he comported himself, that is how a senior advocate of Nigeria should behave. And I used to share ideas with him. And one day I was in court with him, and he was talking to Mr. E.A. Molacha, S.A., not the son of the time, the father. And he said, come here to join us, young man, come here to join us and discuss with us. Even though I'd grown up in a judicial household, I'd met judges, and I'd met good judges. I'd met the father of Sir Louis Banefo. When he's passing to the east, he would stop in our house for lunch. So I met judges, I knew them. I met Sir Betukum, I knew them. But I was petrified. And E.A. Molacha said, I know your father, come here and join us. And I was reluctant. It took me time to come to them, to join the discussion. But that was how we used to see senior advocates of Nigeria. What has happened to the noble profession? A lot of sleaze, ambulance chasing, backbiting. And I met a lawyer who said, he's now a young senior advocate of Nigeria, so to speak. He said, it has become a profession of dog eats dog. I said, I never heard that phrase before. I said, dog eats dog. He said, you don't know anything, doctor. They see you, they will eat you to make money. So my topic is quite a pertinent one. And so what really is misconduct? The categories of misconduct are not closed. It is something that happens all the time, especially these days. But generally, the Legal Practitioners Act says is infamous conduct. Some cases have defined it as despicable conduct. Conduct which a right-thinking member of the society finds contemptible, finds repugnant. What does that mean? I give you a few examples, and I would particularly, while I'm rounding off, mention a case in which I was involved in as a junior. I was a very young lawyer, and a senior advocate of Nigeria took advantage of me, and I was traumatized. And that case went all the way to the Supreme Court of Nigeria. Some people would know about that case. But what really is misconduct? First of all, you must not be dishonest. You must not be involved in fraud of any kind. You must show respect, not only to your colleagues and the judge, but to your junior colleagues. You must address the court with absolute candor. I was in the Court of Appeal as a junior, and a senior advocate of Nigeria mentioned some cases in his arguments. It was not like nowadays where you adopt your brief. You were under real cross-examination by the bench. And Justice Anyalaja said, why have you mentioned those cases? You mentioned the one in favor of your case. What about the ones against your case? You should have mentioned the ones against your case and then distinguished. He was very angry. And those type of things impacted on me as a young advocate. And he called it from the bench, it's misconduct. You must not abuse the process of the court. Too many lawyers, and I dare say senior advocates of Nigeria, abuse the process of the court. This is unbecoming. Now, when you are asked to act in trust, or monies are given to you, you must respect the trust. When monies are given to you, you must always remember the most simple and fundamental principle of accounting. Money is received, must be accounted for. It's a simple and fundamental principle of accounting. Now, all these things I have said, presumably as misconduct, happened to me. A senior advocate of Nigeria did it to me. That was many years ago. Over 30 years ago, about 30 years ago. But it remains fresh in my memory. And at the material time, I was traumatized. What happened? The senior advocate of Nigeria arrested the vessel. His client's car was not found on the vessel. It was not found on the vessel. So he went ahead to arrest the vessel. The Protection and Indemnity Club instructed me. I was very happy. As a young lawyer, you have great shipping gurus like Mr. Louis Mbalefo and at the time, Jimmy Oduba. They were always of blessed memory, which recently died. And they were always against themselves, you know. And then, but I was instructed. So they had a charter party, which the vessel had a charter party, which it had to fulfill in a few days' time. And in those days, you know, the only way of communicating from abroad was by telex. So you wait to receive the telex. And then I decided that I'm going to buy a satellite phone. So I bought this satellite phone I set up in my garden. And when I went to my office, I set it up by the window, and I paid $3 a minute to receive and for. That was the only way I could communicate with my client, and they were on my neck. So I rushed to the chambers of this senior advocate of Nigeria. I said, sir, this is a serious situation. I've not slept all night because of the pressure from my clients. I said, we are prepared to give you a bank guarantee so that in exchange for the release of the vessel. He looked at me, where's the bank guarantee coming from? I said, it's coming from a foreign bank. I go, oh, no, I don't accept a bank guarantee from any foreign bank. I said, what bank would you like to accept a bank guarantee from? I said, the only bank I will accept one from is Citibank. I said, that would not be possible for my client because Citibank is not one of my client's banks. He said, I don't care. You go and procure this bank guarantee from Citibank. Fortunately for me, I knew some people in Citibank who were my contemporaries, and one of them is the current CBN governor. And I went to Citibank, and the whole process of moving money from abroad so that the bank guarantee could be issued was burdensome and tedious. 24 hours elapsed. I was still sitting in the bank, and so it was not possible. So I rushed back to the chambers of this senior advocate of Nigeria, and I said, sir, this is not possible. He said, you know what? The best thing is to give me a bank draft for the full sum of the money. I said, no. My client cannot do that. I said, well, in whose name is the bank draft going to be in? He said, my name. I said, no. My client cannot do that. And he said, well, your vessel will not be released. Talk to the client. The client said, look, let's just comply. The money I stand to lose on this charter party is substantial. So we issued a Citibank draft in his name, and we now, in our chambers, we wrote an agreement that he was to hold this draft in trust and was never to pay it into his bank account. And that when the guarantee is ready, we would substitute it for the bank draft. So he considered, he sent his junior to court. I think the first judge was Kashim J. And the vessel was promptly released, and the agreement was made the subject matter of the release, and his junior also wrote to the court because they thought the junior that was sent would not get there on time, wrote to the court that we have received a bank draft and we intend to substitute it for a bank guarantee. When it is ready, the judge promptly released the vessel. First, he did not keep to his word. He wanted a bank guarantee. He would not wait for a bank guarantee. He had contacts in the bank because he used to bank there. Call this man, call the MD, call this, you'll see that the process is on. He said, no, he didn't keep to his word. You must keep to your word all the time. And from the way I was looking at senior advocates of Nigeria, my thoughts about what they were meant to be have been compromised. Then suddenly, the car that was the subject matter of the dispute showed up. So we wrote to him. The car, which is the subject matter of the dispute, has showed up. It is now in Apapa port, ready for clearance. I don't want to go into the legal niceties of the case. I'm being told to round up. I don't want to go into the legal niceties of the case. But he quickly filed a notice of discontinuance because it was at the time when you were allowed to file a notice of discontinuance without leave. I thought that was a grotesque abuse of the process of the court. And guess what? He paid the bank draft into his account. When I went to his chambers, I took him on. I'm not a man who minces his words. I looked at him in the eye and I said, sir, this is fraud. Yes. It is a clear case of fraud, sir. And I'm disgusted that you will behave in such a manner. He tapped me on the head. Maybe that's what caused my boldness. I'm not sure. And he said something to me in Yoruba which I can never forget. Omo KKK. You don't know what is going on. And he graciously saw me off to the door. Lawyers had heard about this because I've been rambling my mouth, and so the judge refused. I went to the Court of Appeal. I appealed to the Court of Appeal. Nobody believed I was right. I appealed to the Court of Appeal. And I'm not afraid to say so. We had a panel, Solo Gambari, Uwaifo, and Ayola. I was pleased that Justice Ayola was part of the panel because Just Ayola is usually cool on the bench, but you don't want him to speak. Because if he speaks, if he opens his mouth to talk, one question can ruin your appeal. So, and I had wife, but Solo Gambari JCA gave me such a tough time. And the more I tried to explain, the more he shut me out. It was only Justice Owifo who tried to listen to me. But at the end of the day, the decision went against me. Everybody said, sue him, sue him, sue him. Some said, I was playing high stakes. This man is very senior. If you go near him, you'll be ruined in this profession. I said, it only goes without a name in the profession. I can't be ruined. He can't touch me. I know where to go. So I appealed to the Supreme Court. Don't worry, I'll finish shortly. I appealed to the Supreme Court on the day of the case. I just saw 5 stoned and serious justices coming in. Justice Ogundare wore dark glasses. And I thought, oh my God, he's bad enough without dark glasses. They are coming to crucify me now. I'm in trouble. I mean, if you knew Justice Ogundare, he takes you on from the bench and he cannot be restrained. And if he knows you, the more he knows you, the more he would take you on. But I didn't know he had had cataract surgery. And that was why he was wearing dark glasses. And they came in. They were not smiling at all. While he said, call case number so on the list. And we started arguments. We did the basics, we adopted our briefs, and I tried to make some points. As I was making the points, I had gone halfway. I saw the justices were impatient. They were moving. They said, sit down. Sit down. Justice Igbo said, sit down. Dr. Atake, if I may tell you, your brief of arguments is very clear, crystal clear. Your oral arguments before us have been crystal clear. We've had enough. Let the senior advocate speak. I have never in my life seen a senior advocate of Nigeria humiliated in that way. But the court told him to his face, what you did was fraudulent. You paid the money into your bank. Were you meant to pay it? You were meant to hold it in trust. How could you pay it into your account? He said, no, it was a private arrangement between me and the lawyer. Private? What was so private about it? We have it here on record. It is here on record. How did the judge release the vessel? Was it not based on the bank guarantee? On the draft? That's why the judge released the vessel. There was absolutely nothing private about the agreement. You have behaved badly. And in the judgment, Justice Igbo said, and I quote, behavior of learned senior advocate of Nigeria is most despicable. It is unfortunate, and that is the least I would say in this matter. And I remember Justice Igbo very well from that case. When the senior advocate of Nigeria was arguing, he said, look, let me tell you, on my part, I always remember that, it's on my part, I am going to allow the appeal. I don't know what my learned brothers will do, but I am going to allow the appeal. Then Ogundare said, read something in a certain page. Read it! Read it! We're talking like that to a very senior man. Read it! I said, read it! He read, he said, you know that I don't see very well. I know no such thing! What do you mean? And what do you mean? You don't see well. If you don't see well, this profession does not belong to you, then don't come here. So do not put yourself in that kind of situation where you breach people's trust. I was so traumatized even after that decision for years. But I was determined that I must join the rank. I kept coming back and back to the Court of Appeal, Supreme Court. They kept seeing me there and came Justice Owens. And there was Bello. And I knew Bello well because when I launched my book, Bello was the chairman of the occasion. He would say, well, I said, sir, the way I'm going, I've appeared before you so many times. He said, you're too young. You're too young. Him always thought things should be different. Justice Igu, Ogundari, and a few of them thought things would be different. And our set was one of the sets where you had the most youngest silks. And I remember the awe with which this rank was looked at. But that does not exist today. I remember the newscaster, CNN Will Brown. It was always first item on the news. But you won't find that today. We were only 12. The next day, front page newspapers, Omotola, Atake, and 10 others appointed senior advocates of Nigeria. All the papers, 10 papers. Omotola of blessed memory, professor. And that was how it was. There's been so much misconduct. The question I would like to pose before I stop, because I've run out of time. This is not something you can talk about for 20 minutes. Is have the institutions that are meant to uphold discipline, have they not collapsed? I think they have collapsed, or they are collapsing. How is it that an attorney general countermands the decision of the Court of Appeal, a Court of Appeal, and he still remains in our ranks for whatever reason? There are numerous cases. I know you know all of them, but I don't want to go into all of them. But the point is, because it is believed that the institutions which are meant to uphold discipline have collapsed, there's talk that perhaps we'll be better off having a group of laymen who can act suo motu in appropriate cases to try senior advocates of Nigeria and other lawyers. When the issue comes, they are laymen, they would not know. Okay, the chairman should be a lawyer, a renowned retired judge or an experienced lawyer. These are the issues. The institutions meant to uphold the law are collapsing gradually. So too are the institutions meant to uphold discipline. In conclusion, I would say to you, as you move along in attaining this rank, watch your step. Mind the gaps. Mind your step. Look right, left before you move. Be careful. Because so that you don't do the wrong thing or you are not accused of misconduct. Because any act of misconduct will stick will stick, and you may not be the same person again. Always bear that in mind. You can see that I told you about a case that happened 30 years ago. It's in my head. And I know many of you will come to me and say, who is the senior advocate of Nigeria? I'm not saying, but look at part 500, page 1. The case is reported there. Part 500 of the Nigerian Weekly Law Report, page 1. You will find it there. Ladies and gentlemen, I wish you well, and I thank you very much indeed for your time.
Being chastised by the apex court. So I think that this is important, that we keep in mind sanctions, discipline come from disbarment, desilking, suspension, admonition, or part 500, page 1. I'm going to invite the next speaker, Mr. Dele Additional, SAN, to please talk on accountability, discipline, leadership, and regulation.
To be asked to take this topic, which I question legal ethics and professionalism in the practice of law, accountability, leadership, discipline, and regulation of senior advocates. Somebody says that truth is universal. Nobody has monopoly of it. If it appears that a good number of the facilitators have said in different forms or the other what the earlier speakers before them have said, it is because the same point is agitating the mind of the speakers. I've gone through the folder and I found out that my paper is there. It's 21-page paper. I will just speak through it, but I want to please plead with you to find time to read it. I traced the history of Senior Advocate of Nigeria to 1975. I also traced when even QC was imported to Nigeria, and it has to be stopped after we had our republic in 1963. Let me congratulate each and every one of you. And this time around, I will not limit my congratulations to you seated here. I will also congratulate your families and your associates in chambers. I mentioned some of the early, recipients of these very great titles. The first two in 1975, the first 13 in 1978, and so on and so forth. And like I said, virtually all these great leaders, titans in the legal profession have gone. But there are some of them that have gone, and you still tell solid and positive stories about them. That is the essence of life. And I believe that is also the reason why we are doing all this. I talked about the rules and regulations, and I say that the rules of professional conduct for the legal profession, 2007, I expect each and every one of us to be familiar with it. Please, I'd like you to take that rule once again, because this is the beginning of a new beginning as Senior Advocates of Nigeria. Yes, you can say law is the same, you have been going to court and coming out, but your approach, what you do and how you do it, must change from what it used to be. Rule 1 of the rules of professional conduct provides that a lawyer shall uphold and observe the rule of law, promote and foster the cause of justice, maintain a high standard of professional conduct, and shall not engage in any conduct which is unbecoming of a legal practitioner. The gentleman you will read about in that part 500, and you know how many years ago that, will continue to be a bad reference point. And the greatest wise man or woman is that person who learns from other people's mistakes so that it doesn't commit the same. Now, I listed out the additional effort that the body of Senior Advocate of Nigeria has taken to put together a code for the Senior Advocates of Nigeria. I captured the code, and one of them is that all members, when they appear before any court, tribunal, or administrative body, or quasi-judicial body, shall accord the greater respect to those presiding, and shall not, in words, deed, or behavior, do anything to diminish the dignity of any adjudicatory body. And any member that appears as counsel in any matter before any court, tribunal, administrative body, or quasi-judicial bodies shall provide leadership in terms of decorum comportment, language, and learning. Some of us use even merely addressing or announcing the appearance in court. You will wonder, is this person talking to his houseboy? Why is it behaving like this? Is it the only person that will be senior advocate of Nigeria? Once again, I pray that we shall not be a bad reference point. You have come into this rank, and if I have the permission, I will constitute you as the new generation that will begin to do things in a different way or form, in addition to those that are already on that path. Our society is getting impatient with our justice administration, which many have contended to be ineffective, inefficient, and dysfunctional. This has also been said by one of the speakers earlier. But why are they getting impatient? Is it their fault when a case will last for 20 years? Is it their fault when, as professionals, we cannot advise our clients to say, I don't think this is a case to fight? Why can't you explore settlement? Why is it we can't advise them to say there is no point going to court? By the time you are putting together your commercial agreement, you made a provision for arbitration. And having exploited that process, and an award has been rendered, and there is even a provision in that agreement that says the award shall be final. Why will you stay in the face of this advised to go to court? And when you study the Arbitration and Conciliation Act, you will discover that the windows for intervention, judicial intervention, is very, very narrow. There are cases where parties have concluded arbitration as far back as 19 years ago, and they were still in court until the early part of this year. Will this encourage the users of legal services? The answer is no. My Lord talked about the enormous list of judges. It's all of them. It's not limited to the Federal High Court. In Lagos State High Court, there are judges with more than 1,500 cases in Lagos. I have itemized some challenges that we must now confront ourselves with. My big brother there, Mr. Ken there, was asking the question frontally, what can the body of senior advocates do to address some of these? It is high time we take on the added responsibility of finding creative solutions to some of these problems. And one of them, like I stated here, is delay in the administration of justice, congestion in our courts, generalization of corruption in the nation's judiciary, inadequate funding, endless preliminary objections. Some of us believe that the longer your argument takes, the more skillful you are, even when you are talking rubbish. I had a little experience about 3 or 4, well, just about Friday last week, exactly Friday last week, when a counsel, a very senior advocate of Nigeria, I use various to qualify him, was arguing that a process was taken to another chamber, to my chamber specifically, and that the chambers refused to accept service. And I got up in anger. I said, let's reverse the case. If I ask my client to go and serve a process in your office, the office of a senior advocate of Nigeria, and it tells me that it was rejected, I said, I will not believe you. I won't believe the clerk. I will say it cannot happen. I said no such thing was served in my office. In any event, will it not be to the disservice of my client to refuse a process? I said your junior has served 5 different processes in our office and we accepted it. Tell me why we will refuse to accept this one. It was still going on and on and on and on and on. It took the intervention of the presiding judge to say, look, I do not believe your assertion. In any event, the affidavit that was sworn to did not even state the address of this council. So where did he go to? There are some things that we should not floor. Once we know the right thing, we must do it, rather than arguing for argument's sake. Now, talking about professional standard, I said, the side some of us represent as council determines how fast or how slow the proceedings must run. Some of us now are importing the evil strategy in election petition cases, whereby they will wait till Friday before you are served the process, so that you won't have enough time to prepare a counter process to be served in reply. These are things that we must try and run away from. In a paper titled Towards a Better Administration of Justice in Nigeria, Case for Systemic, Structural and Attitudinal Transformation, delivered in 2019, 11th of July, I stated that we must recognize that a fair characterization of a legal practitioner's responsibility is the fact that he stands as a shield in defense of a right and stands to ward off wrong. In a profession charged with such responsibilities, there must be exerted those qualities of truth speaking, quality of high sense of honor, and of a stringent observance of fiduciary relationship. It is very important for us to know that doing the right thing is to our own benefit, much more than even the benefit of society. Because when you begin to be a reference, oh, can't you see that SAN? I mean, that's an exceptional person. That is not, it's not among the rank that anything goes. Now, it is very important for us to make up a decision that I want to be different. Somebody once brought a case to my office, and at that time, not just me, myself, God knew I needed money. He brought the case, he had fought an election petition up to the Supreme Court and lost. But after losing at the tribunal, I went to the Court of Appeal. The Court of Appeal gave what I can say 2 judgments. The first judgment was given without a reason, and they said reasons will be advanced later. By the time they were advancing the reason, the 60 days allowed for the case had expired. So he went to the Supreme Court, and the Supreme Court held that what the Court of Appeal did was a nullity. The judgment without reason was not a judgment. And by the time they gave the reasons, they no longer had power to do so. And the Supreme Court ended there. After about 2 months, that judgment had been rendered. The gentleman was introduced to my office, and he brought a heap of files and what have you. He wanted a counsel to go back to the Supreme Court for review of that judgment. And as I will usually do, I told him, go and come back. And by the time he came back, I told him, meanwhile he had done all research. He knows how to do on the meaning of nullity, the word nullity. He said it is very clear that the meaning of nullity is that the thing did not happen. So, if that judgment did not take place, then the Supreme Court ought to have gone further to assume the role of the Court of Appeal and give judgment on the merit. I said, you have a very good point. I said, but whether it is a review or not, it is still an offshoot of a political case. And the Supreme Court handled 60 days, which days had expired. So I am sorry. Next time we better. It's only for 4 years. Go and prepare for the next time. He left me very, very angrily. But he went to Abuja and he got another senior advocate of Nigeria who went to the Supreme Court for the application to review. And if you have 5 justices sitting down, and you take 30 minutes to argue that application, multiply 30 by 5. That is the time that you have wasted. Of course, the application was thrown out through the window, and the judge, the lawyer, was personally held responsible for cost of that action. I have gone my paper to mention some cases, and I want us to read some of these cases and hear the remarks of the court about some of us. The reason for this is for us to also learn what we must do and what we must not do in order to uphold the ethics of the profession. In the case of Metro Line Nigeria Limited and others versus DICO, the Supreme Court said, I intend to comment on the disturbing trend where all manner of appeals are filed against awards. It is the duty of counsel to explain the nature of arbitration and not to encourage their clients to disregard them when they get unfavorable awards. The unfortunate trend in which litigants, with the assistance of counsel, who fail to appreciate their duties as officers of the court, all in a bid to win their client's case by all means, bring unsubstantiated and spurious challenges against otherwise good arbitration ought to stop. In another case, Economic and Financial Crimes Commission against Dr. Thomas, the Court of Appeal said, I find the submission that the respondent was exporting the money from Lagos to Abuja laughable and preposterous. They found the money with somebody who was at the airport flying to Abuja. And so to break that offense under EFCC, they said he was exporting money from Lagos to Abuja, as if Lagos was now in Caribbean. It should attract no comment because it is sad that such submission could come from a counsel, a person fit and proper that was called to the bar. Very sad indeed. Courts have over time admonished counsel to guide and assist the court to see and know the truth and to do pure and undiluted justice by placing all facts on the table, even where the facts disclosed may not favor or work in their interest. The quotations are there. I also cited Shashangi Airlines against AP. Some lawyers, they will recognize the truth. Their client has benefited under an agreement, but in order to defend the indefensible, they may be raising illegality and one useless defense or the other, which is also not right. Now, I will skip the pages and go straight to leadership, because virtually everybody that has spoken here today has said that the rank of senior advocate of Nigeria imposes a responsibility, a leadership position on the recipient. Now, A.B. Mahmoud said, please give me 3 minutes. A.B. Mahmoud said that this is indeed a mark of professional excellence that each and every one of you richly deserve. You now share with other leaders of the bar the burden and responsibility for professional leadership that the rank of SAN imposes. By your new position, you are a role model for the profession. So many people have also talked about mentorship here today. Whether you know it or not, you have become a role model. And it's a position that you must meet and meet very well. In sharing with other leaders of the bar the burden and responsibility of leadership, the rank of senior advocate of Nigeria imposes on you, let us bear in mind the statement made by one of our members some time ago. UFO Nnaemeka is his name. He's a legal practitioner. He said, history celebrates leaders who make right decisions. History forgives leaders who make wrong decisions. But history will not celebrate or forgive a leader who makes no decision at all. Don't let us look as if something does not concern us. The other time I was at the Federal High Court here with about 3 or 4 other colleagues who were just discussing, waiting for the court to see. And a counsel passed us by, and I found out that he was wearing a black jacket and ash color skirt. I asked from the colleagues, I said, this is not right. Should we call her? One of them said, let her go. She may be rude. Okay, if she's rude, let us be seen to have done our work as leaders. So I invited her, and I stepped aside from the other colleagues. I said, young lady, how are you? Good morning. You look very beautiful. How old are you at the bar now? I said, please. You know, when you were in the law school, you were taught there is what we call regulation dress. Black up and black down with your white wherever. I said, your skirt is not white. And to my greatest surprise, positively, she said, sir, I am very sorry. I took for granted. I won't do it again. I rushed out of the house. So by the time I came back and I told the colleagues that, do you know that the lady felt very happy to be corrected? So please, let us ensure that we do the needful. And nothing is too small to correct people. In conclusion, I said, distinguished ladies and gentlemen, permit me to say that your success and legacy will not be the function of how much you have in the bank, but the function of how many you are able to mentor, either through direct mentoring or indirect. Thomas Jefferson, former president of the United States of America, once said that every generation needs a new revolution. We cannot continue to do things in the same way and expect a different result. The bar is waiting for a new generation of leaders who will be driven by superior motive to put public interest above self-interest in order to render a selfless service to the humanity. We need a new generation of leaders who will accept responsibility to rescue the bar and who will champion renewal of hope for trust and confidence in our judicial system. Al Gore was a former presidential candidate in the United States of America. He lost an election and he fought that loss to the highest court, the Supreme Court of the United States. And he lost. As soon as he came out, he faced the press. And he had this to say, I've never forgotten. He said, I disagree with the judgment of the Supreme Court of the United States of America, but I accept its finality. But some of us will be aiding and assisting our political clients as if the institution of judiciary has an alternative. Everything we say about it is to bring it down. There's a difference between criticism, and I think that point has also been made earlier today. There's a difference between criticism of a judgment and criticism and damaging commentaries about the judex. There is a new responsibility on us to defend the judiciary. Whatever you do not advertise does not command attention. Let us begin to rewrite the story of the judiciary in this country. There is no alternative to it. When somebody is standing by you and is saying every derogatory thing about it to bring it down, caution him that if you have any problem today, that is where you will go tomorrow. At our own individual areas of influence, we can decide here and now to begin to effect a positive change in the practice of law, in the judiciary, and even in the nation as a whole. After all, every great institution is the leading shadow of a single man. I recognize that God does not look for masses when he wants to do something. He looks for a leader. In Ezekiel chapter 22, verse 30, God said, I sought for a man among them that should make up the edge and stand in the gap before men for the land. Gentlemen, we must stand in the gap to defend the judiciary. If that place is brought down today, whether you are a senior advocate of Nigeria or a super senior advocate, you have nowhere to go. And people are coming to you because they still have some level of trust and confidence in the system. We must take proactive steps so that we can increase the estimation, the prestige, the dignity, the honor, and the respect of this institution. When we are doing that, we are doing the same thing to ourselves. Thank you very much.
Something, it's called a concentration revamp. I'm going to respectfully urge you to rise, just like me, to stand. Don't go anywhere. and then a bit to the left, a bit to the right, and you can raise your knees a bit, and then thank you very much. Please be seated. It's not a yoga class. Let me now invite distinguished Professor Oluyemisi Bamoshe SAN, who will share some insights on advocacy through research. The floor is yours. Thank you.
Thank you. Distinguished ladies and gentlemen, I have a slide. Please enlarge the slide. Legal research. Advancing legal practice through legal research. And the question that will come to mind is that what have we been doing since? How do we take our cases to court? We've been doing legal research. But go to introduction and please follow me. But what we are going to be talking about today is that we are taking up a new role. We've heard that this is a mark of excellence, a privilege, but it has some rights. So with the privilege, it comes with some rights, and there are some expectations. When you look at the duties, many of the previous speakers talked about the duties of the senior advocate of Nigeria. They are fivefold: to the legal profession, to the client, to the judiciary, next slide, to the state, and to the public. So it is fivefold. When we talk about the award of the rank, we know that primarily it's to the advocates, and exceptional cases to the academics. And that is why we have only one professor that was given this rank. Now, it's an exceptional case now under the new rules. In research and publications that have become, please take note of that, that have become major source of references for judges, legal practitioners, law teachers, and the students. So we must make significant contributions. So, especially for those in academics, being a professor of law and a senior advocate, it requires a great deal of balance. The balance of responsibility to the academic institution, and not only the academic institution, but also to the legal profession. So, we are to make substantial and significant contributions to the judiciary, to the state, and to the public. Previous speakers talked about the society looking at us, our communities looking at us, the judiciary looking up to us, and the importance of legal research. To senior advocates of Nigeria, it is very important. It is compulsory for all legal practitioners. But for the senior advocate of Nigeria, please let me tell you clearly that it is mandatory and indispensable. You will see the reasons. Without legal research, a legal practitioner cannot adequately meet the needs of the person or group of persons he or she is offering services to. There's a new you. There's no doubt about this. And to whom much is given, much is expected. In a couple of days, you are a new wine, and you cannot be put in an old bottle again. It will explode. The appellation will change. Now people will call you Senior Advocate of Nigeria. The sitting position in court will change. And I'm sure that Ajogo SAN will come and tell you about the functions. Even at functions, you will not sit at ordinary tables with ordinary people again. There will be a special table for you. So all things are passed away, all things have become new. The next slide. Now, as senior advocates in this area of legal research, more eyes are on us. Next slide. More eyes are on us. People will want to see, now that he or she is a senior advocate of Nigeria, what is new? Let us see. So all eyes will be on us. What is he going to say? What is this legal practitioner who is now a senior advocate? What is she or he going to say? You are going to make a distinction. Please, I want that slide to be on because no. You've gone further than that. Please go on. There's a pencil I want them to see. Yes. You are going to make a distinction. Ladies and gentlemen, look at that. There are 4 pencils there. 3 of them are very dull, but one is really sharpened. And that is you. Because you have to make a distinction. Because you are a senior advocate of Nigeria. And then things must be done differently. While others may be going that particular way, you can see that red arrow. That senior advocate must do things in a particular manner that befits the senior advocate of Nigeria. So what do? Our teaching methods for those in academics must change. There is a town and gown principle in which one will be able to talk, statements and opinion of jurists and learned academic authors may be very relevant to judges, legal practitioners, students, and the government in resolving the legal issues. What do? There's something we call secondary sources of law. These are sources of law that do not carry a dominant legal weight and binding effect. But they're very useful in the court of law or resorted to where the court finds the opinion or fact underlying the authority contained therein. You will see when we're talking about books, we recently talked about the book of Dr. Atake. There are books written by Ajogo SAN, and these may not have legal binding effect, but they are useful for the court, where the court finds the opinion or facts underlying the authority contained therein. So these secondary sources, that is where I'm going to, can be referred to in the court if it supports the authorities of the primary sources. What do? In Aminu versus the state, always a JSC in deciding an issue on whether the onus is on the prosecution to prove or disprove the plea of self-defense, referred to a criminal law book in Nigeria. Incidentally, I was so happy because I wrote that criminal law in Nigeria. And I was so happy in that case to see that my book was cited in that book by the learned, the Honorable Justice in the Supreme Court. And I felt happy. And it is not just because I'm in academics, but books of other people, as we will see. Olisa Chukura, Unwa Boise, Benuwa Boise, SAN, all those people, they were not in academics, as we say, they were in practice, but they wrote books. So some of the things that we're going to do, it is going to be with distinction. It is going to be with a difference. You are going to go into sources of law that can help the courts, that can help other legal practitioners in what they're doing. Again, there was this famous case of the Synagogue Church of All Nigeria, of all nations of 2014, which I'm sure many of you read about the collapsed building, where 116 people died and 2 engineers were charged for manslaughter. Again, the DPP of Lagos State in that case referred to a book published, Collapsed Building Sagas, Liabilities Under the Criminal Law, in Egyptian Journal of Legal and Economic Studies. It's a foreign journal. What am I trying to say? Incidentally, again, the DPP contacted me and said that I wrote a book on collapsed buildings. I said yes. And she asked me. She said she's now a judge, and she asked me, what is the import? And I said, those engineers or persons can be charged for manslaughter or murder in cases in which there is an intention, or where there is no intention, you can see that they had, you can imply that intention. Because when you are supposed to make cement to use 20 bags, and then you use 5 bags, what do you think that story building is going to carry? And that was one of the arguments. What am I trying to say? Things that you write, you don't need to be in academics. As a legal practitioner and as a senior advocate, to whom much is given, much is expected. We can write new areas of law in which they can use, in which the courts can use. We're there to assist the judge. Remember what I said at the beginning, that it is fivefold. We have a duty to the courts, we have a duty to the society. So we're there to help the courts. So whatever we do will help in advancing the cause of this. Now, look at assisting the bar and the court. Look at that case of Contours Nigeria Limited versus UBA. The court in that case said, be alive, talking to the legal practitioner, be alive to your responsibilities to assist the court. So as senior advocates of Nigeria, we have a duty to assist the courts. Then we have to seek ways to make the work of the judges less cumbersome through regular and update research. Whatever we bring to the courts must be things that the courts will find the work less cumbersome. Look at the admonition of Lord Denning in Parker versus Parker. He said, what is the argument of the other side? Only this, that no case has been found in which it has been done before. If we never do anything that has not been done before, we shall never get anywhere. The law will stand still while the rest of the world goes on, and that will be bad for us. Look at what happened in Abdullahi 2018, and that was by a senior advocate of Nigeria. It was something that had never been done before. It was something that was novel. But I'm sure that it wasn't the client that just brought this case. It was the ingenuity of the senior advocate of Nigeria. And just like Atake SAN said, quoting a particular law report in which you will see a senior advocate, what the person did that was so damaging, the same way you can read what the senior advocate of Nigeria did in 2018. This case had never come before any court of law. And I'm sure that it wasn't the client that came up with this ingenuity. It was the legal practitioner, the senior advocate of Nigeria, that sat down and thought that because it has never been done before, but there is something to it. And they went to the court, and the court was so happy. Look at what Algi, who read the leading judgment, said. This application for substitution raises a novel issue of whether applicants can be substituted for the deceased applicants. Look at what ACA JSC said. This application is no doubt a novel application. Kekere also said, this application is quite novel. And Gallinger JSC said, I must admit that this is a novel area of criminal jurisprudence. How good will it be if you, as a senior advocate of Nigeria, you are the one in this law report and not the one that Atake SAN said, that they can say that you've done in that area. So what can we do? We can outsource legal research to experts. If you do not have time, we have experts, put them together. If you do not have time to do this legal research, because it is very important, it portrays you in court, it portrays you in front of the society, in front of your community. So outsource it to legal experts to treat for you, to look into it, and you can use experts. You can invest in legal research tools. There are so many, the Google Scholar, the Law Pavilion. Please, we've talked about technology. Please invest in this and make sure that we use it. Your research experts can use this, and then we embrace technology. It has been done before, so it could be you, and it must be you. And this is a new generation of senior advocates of Nigeria. If Ben Onwebweze SAN could do it, Inoyelowo and Oyewo is a case in which a textbook by Onwebweze was used. Olisa Chukura also has done this. He wrote on author of a digest of Nigerian cases. Kasumu has done this. Even Chief Mrs. Folashake Sholanke, she has written so many books which we are using in the courts and very relevant. So why not you? So who is next? You must be next. And what are the effects of non-performance? Number one, irrelevance in the rank. We must remain relevant in the rank of senior advocates of Nigeria by contributing substantially. Don't just be a senior advocate by mouth. Don't let them say that, oh, she's just a senior advocate, he's just a senior advocate. You must be able to do something to the court, like it's done in Arad Abdullahi, not like in the case cited by Atake SAN. It shall not be your lot. It shall not be that you are just a senior advocate of Nigeria. So what? Nothing is done. Nothing is gotten. But like Olisa Chukura, we'll never forget Olisa Chukura. We've never forgotten Onwebweze. And we have Adogo, SAN. He has written so many books. You know his area of specialty. And my Lord, Honorable Justice Owade, you know, when you talk about criminal law, criminal jurisprudence, you are talking, please celebrate him. He's retired but not tired. So, what is the effect of non-performance? It can be an embarrassment. We've talked about that. Look at Gibbs and Gwen. The court commented on the lack of professionalism in which the counsel handled the case due to lack of research. And the judge ordered that the lawyer should hand over that case to the clients. That the reasoning he had, he should go and explain it to the clients. That was so shameful and an embarrassment. If you look at Unijust's case, in that case, the Supreme Court ordered why a square peg was put in a round hole. I don't expect that any senior advocate will be so described. Again, we are looking at Ojora and ASP. The court said wonders shall never end. It beats our imagination how learned senior counsel expect these courts to denigrate the authority of the final court. We've talked about that. No confidence. People will have no confidence in such a senior advocate if we do not engage in legal research, and it will have a negative impact on reputation on the person, because the legal community, as students, lawyers, I mean, want to just talk about something. Recently, a senior lawyer was citing the Evidence Act 2004. Evidence Act 2004 in 2023, when there is 2011, when there is 2023 amendment, a senior we must not talk about it. And it was a student who pointed it out that what is this? Why is a senior advocate pointing out this one? So we have to be on the watch of confidence in that. So what are the recommendations? The recommendations are that we should invest in information technology. Then the training in respect of effective legal research methods, including how to use technology effectively. Then we should foster interdisciplinary collaboration. We should encourage collaboration between legal practitioners. We have our legal practitioners coming together and discussing issues. And then we support legal tech startups, and it can encourage legal tech startups to develop tools and technologies for legal research. It is very important that we are conscious of our personal investment in conferences and workshops. It is not meant only for those in academics. Please, those who should go for conferences, we go for IBA, please invest in this. As senior advocates, it is now time for us to go to conferences to see what is new, so that when they are talking about a particular area of law, we know it. Then we talk about mandatory continuous legal education for all senior advocates of Nigeria. I know that many of us cannot go back to school, but we can have continuous legal education. And then intensive research work in new areas of law. One of the previous speakers talked about so many things about new areas of law. And I am going to emphasize this. You do not need to personally, although it is good for your own education, but you can constitute a legal research team to look at these areas of law, and then you come in so that they can discuss this with you and deliberate research work in topical areas in focus. I also recommend that we should establish a research team, mentorship and effective leadership. We're talking about people in the universities not doing what they're supposed to do. But when they come for internship, please, this is encouraged. And even as senior advocates of Nigeria, please, I implore you that you can do pro bono, not cases, pro bono work in the universities. You can come to the universities. You can go back to your alma mater. You can go and to the faculty of law to go and talk to those students, to motivate them, to inspire them. There is declining standard. But when we go there, when we talk to them, when we give them some lectures, it will encourage what we are talking about. Also, we're talking about dedication to thoroughness in student supervision to make sure that they do what they're supposed to do. In conclusion, the courts are but a flowing river, and it is the duty of a legal practitioner, whether you're an advocate or in academics, to guide the flow of the river. How much more a senior advocate of Nigeria, to whom much is given, much is expected. Please, as senior advocates, your legal research should be much more enhanced than it is before. Congratulations and thank you.
So another round of applause for her. Thank you, Professor. We're short past time. Question and answer. Simple rules. No observations, just ask a question. No provision of facts, just ask a question. Just so that we can manage. We'll take 4 questions. There are now 4 geo zones in the room. 1, 2, 3, 4. So 1 from each on a first hands-up basis. Number 1.
Just an observation, I noticed that the learned sick, Mr. Debo additional, I have his book, but the other ones, I don't know, Mr. Debo additional, we have his here. But the last speaker, Mr. and the learned sick, Mr. Atake, we don't have his work because our people can get them very, very good.
Thank you very much. Thank you. That you have in your binder, but you will get some slides later on. summaries. Thank you. Your question.
Thank you, sir. May I respectfully stand on existing protocol? My name is Ayo Tunde Okunleye. I would like to start my questions by first appreciating our fathers who created this rank and have attached the integrity and dignity that the rank carries. I also want to thank BOSAN for this wonderful opportunity. My first question is BOSAN aware that there are so many senior advocates of Nigeria out there who need this kind of training? And so for that reason, perhaps we should have a conference for senior advocates. Secondly, the issue of training of senior advocates, particularly as leaders, as specifically pointed out by our dear learned senior advocate, Dikin Dele Adeshina. Is it possible for BOSAN to partner with any of the schools of leadership, say for instance, the Lagos Business School, the training. My third question, is it possible?
And that's the last one.
I have about a few. Is it possible that some of the things we are being taught here today could be taught to persons who are non-senior advocates, our juniors, so that they can learn not only that you have been designated, but the fact that you aspire should mean that you should learn the culture, so that the training can then capture them when they are young. As a matter of fact, is it possible for BOSAN to run an institution like a school where a person can actually learn the practice, the culture of becoming a senior advocate of Nigeria? I have been told to make it the last, so I will make this one, and this is important. Every single time I listen to an advocate who was trained in England, they inspire something in you that is different from what we see regularly today. Now, is it possible for us to have an exchange program where, one, senior advocates can actually exchange with people who are queen or who are king's cancer in England and have opportunity of relationship and interaction? Is it possible for BOSAN to organize this kind of concept? Are you aware, sir, that today members of the inner bar in Nigeria actually attend visa interviews and they are denied? What presence do we have on the international front as BOSAN? We are selected human beings now. We should be accorded this dignity. And finally, I checked the list and I found that so many people are dead. 136 out of 754. What is BOSAN doing about the health of senior advocates? Many of the best breeds are dying off. What are we doing to ensure continuity? Are we also aware, in terms of billing and finance, that there are so many senior advocates of Nigeria that are running out of practice and can no longer even fund their firms? What are we doing about this? Thank you for the opportunity.
If anyone wishes to, otherwise, the bulk of these questions are perhaps good observations, things to keep in mind. And don't worry, there's now, by God's grace, from 11 a.m. on Monday or 12 noon, it will now be what will we do? Okay? So, I'm going to just respond to one thing and then ask the secretary of the body, Mr. Shufo SAN, to respond to the issue about whether there's the need to give this training to existing SANs. Mr. Shufo.
Thank you for that question, Mr. Watts. So that between now and Monday I can decide what can happen to you. All right. In all seriousness, this is the 6th edition that we've had of this induction course, and along the line, we've had several senior advocates who never had the benefits of this training, saying that they are also interested. As a matter of fact, what we have done now is we started in October this year. We actually had a webinar in which the relationship between counsel, that is between a lawyer and another lawyer, and senior advocate and another lawyer, were discussed. We discussed it at length. I mean, we were there for we had about 99 participants, which were not limited to senior advocates alone. We also had some other lawyers of the outer bar who actually joined us on the webinar. So it's something we plan to be having every quarter, or maybe once every 2 months, so that what the senior SCNs may have lost, we probably will catch up, because most of the things we're going to be discussing are matters that we have discussed this day. We've been discussing all morning, and we'll just take them, find, for example, the one we held, Mr. Gobamian was actually the moderator, and we had the OCG Okocha, we had Mrs. Funke Adekoya, and we had Yeke Gadzama as the speakers on that occasion. So the next one should be coming up in January or February. So be on the lookout for that. Hopefully by then you will have been conferred with the rank, and then you can just join without any inhibitions. I think so far, in terms of training, I think that's all we can say. As a professional organization and as leaders of the bar, we don't see why we must partner with the Lagos Business School, because we're not business people. Let us keep, I'm saying this, I know that Professor Ajogo is one of them in the business, so I think he likes money because he's from that part of Nigeria where they love money so much. But honestly, it's food for thought, and maybe the years down the line we can consider that. But for now, let us teach our members the very best of the ethics that they truly deserve to show how to become new SCNs. And the old SCNs, like you said, will learn by backward integration, whatever it is that they may have lost. Thank you very much.
This brings this segment to an end. Before we start the next one, I'm just going to request that we take a 2-minute break. If we make it too long, then we'll prolong the ending of the day. So I'll plead with you to just take a stretch. I try to lay out a few words about what I've referred to as the dignity and the rank of Senior Advocate of Nigeria. And I say that slowly with depth and understanding that this is something that is status changing, not just externally, but internally in the mindset. And that is really the thrust for this program. So much has been said about the duties. I will utilize the session I have with you to pretty much take much of questions and a few things that are not written out anywhere, but which you will meet from day to day, either in the courtroom or outside, and prefer what should be or what is the applicable thing. Success, they say, breeds envy. And so the price of success oftentimes is envy that is not seen or felt. So I will give you some statistics. From the coming of the British to 2019, Nigeria has admitted 197,000 lawyers. It has admitted an average of 4,000 every year since then. So it is safe to say that we have about 213,000 lawyers in Nigeria. Now, from 1975 to date, including the living and the dead, there's been 754 persons elevated to the inner bar called Senior Advocates of Nigeria. By God's grace, close of business on Monday, adding 58, there will be 802 such persons. Now, when you are talking about IKIM tops, Harvard style, top 15% alpha A, in schools that are very strict, Professor Nadeko has led and graduated many lawyers through the Nigerian Law School. There is products. Top 10 will be proud to say we are topmost. A, alpha. Now, top 1% is genius, rare. Say I'm in the top 1% of my class or profession. Now, you work out this maths, 802 out of 213,000, and you will get, you are now top 0.38%. Jeez. It's called rarity. And I say this so that you can reflect on what transformation you're going through. And so why all of this energy, the best of our best, literally preaching as it were, be good, walk straight, do things well, wear the rank well. This statistics should tell you the reverse, which is, I should be walking well, straight. And the things that I did before, I should do them better, and I should avoid a few other things. So this statistics I've shared with you is the reason why I want to just mention a few things on excellence. Now, there are a few things I would read through on the screen, and I'm not taking the full session. I would spend more on the tidbits I want to share. This is what Den and Emma had to say in Randall and Worsley. And the colleague of ours, Mr. Gule, have said he's impressed and inspired when he listens to our colleagues who trained and qualified where we borrowed the law from. Obviously, they trained out there, they interacted, they're cross-culture, they understood diction, pronunciation, mannerisms, courtesy, respectfully disagreeing with people, with courtesy. We just don't say with all due respect, then you go aggressive. With all due respect means I will offer you superior reason why my views are better than yours. So as an advocate, he is Minister of Justice. Expression abuse, but that's what it ought to be. He has a monopoly of audience in the higher courts. You will. And not just that, but to mention your case now out of turn. Now, let me qualify what the rules say. It is where is the motion, right? To mention it out of turn. But a lot of judges will allow you to mention everything out of turn. But I've just said this because somebody may challenge you if it's a criminal trial. There are people who will challenge you out of you are 0.3%. And there are always those who think that, well, who do you think you are? So you got to be very careful. You will meet those in court who will argue with you that they're benchers, and therefore they will take precedence because one section says that it's the body of the highest distinction. We have argued this before a judge of the Federal High Court and is giving a ruling that the table of precedence in the Legal Practitioners Act is where that argument is resolved. That table says AGF, after AGF, Attorneys General of States, Attorneys General of States, in accordance with their seniority as SAN. After that, Senior Advocates of Nigeria, in accordance with their seniority. And if they're both sworn in the same day, one will be older at the bar. If they're both called to bar the same day, we've had a presidential election for sure where one of our team members was senior because of his alphabet. They were both sworn the same day, called to bar the same day, but one was I and one was N. And he flexed that seniority to the end. So it is important that you keep this in mind. I have had to argue that have the court adopt that table, and in deference to the old man who was above 80 at the time, I asked the judge to allow my privilege to go to him since he was much of gray hairs. Now this was my privilege being given to him. Now, the instrument, and I try to just show a copy of that instrument. I hope I'm not violating someone. That's my father's instrument. Speaks about the dignity, that at all times you will carry the dignity of the rank. And those expressions are not used loosely. That is actually embedded in the oath. The next document, and you'll get the slide, is the oath that I expressed in the morning. That oath would try to talk about your duty and undertaking, and you will swear to assist the courts, uphold the Constitution at all times, and that you would do this keeping in mind the laws of the Federal Republic of Nigeria. And why have I said this? This is because those things were summarized, because this is often where the booby traps that pull down SANs come. And I will just flip through the next slide. I'm distributing this, I don't want to go through it. Next slide with all ethics. Now, I'll pause here. Just a heading. A duty to take instructions in chambers. However you portray yourself or carry yourself without meaning to qualifies the tag, price tag people will place on you. If a client snaps his finger and you meet him at a restaurant and sit through his pleasure to listen to his instructions, he will fix what he thinks is your worth. If the same client calls Dr. Atake and Dr. Atake tells him that he is right now finishing up a game of golf and he will accommodate him on perhaps Tuesday evening, that client, I tell you solemnly, will pay him a whole lot more than the one who was easily available. There are exceptions to the rule. If an elderly man of age wants to give you instructions, perhaps culturally, perhaps is physically impaired, or it's an emergency, or there are about 30 other people, they can't move to you. There are exceptions which you can look out, but the thrust of that message is, thou shalt not cheapen yourself knowingly or unknowingly. Next slide. Next slide, please. Now, so in observance of the law, it looks so obvious. Why is he talking about this? Very often you find that our colleagues, in pleasing clients, just breach the law a bit. And in breaching the law a bit, you find yourself on a slippery slope where you breach it just a little bit more, and then a little bit more, and deeper more, and then you're in a mess. You may not be the target. You may just be collateral damage while they're pursuing a political opponent. And then the lawyers who helped to collect fees, as innocent as it looks, from the state for defending a candidate. The state paid you for defending a candidate. By the time you come out with your arguments, you're all over the social media. Google has your name, and you know those trials that happen on the media. X is being grilled by the commission for 9 hours. There's been no charge. Just being grilled, it's already bad news. So I implore us at this rate to weigh carefully things you do out of self-preservation more than anything else. To stay away from it. There's some obvious things about influence, about corruption, about bribery. You decide whether you now eat enough 3 square meals and you don't need a fourth. If the fourth is going to be a fish bone, the 4th meal could be a fish bone. And you know where it gets stuck? The throat. Next slide. Go on the next one, please. Now, conflict of interest issues, you should take them very seriously. If I've acted for A and B says, I must go after A and I've received information, please stay away from it. One of us, 2013, had a strong petition before the LPPC. He hadn't even acted. He went through the files of A, told him he doesn't want to do the matter, and took brief from B and acted against A. A said, but I've shown you all my secrets. He nearly got desilked. Very, very thin line, he almost did. Conflict of interest. Next slide. Now, client attorney fee issue, I've mentioned the source of the fee, so be careful. You should also be careful when things are being passed through you. I'm going to, how much is your fee? 50 million. We're going to pay you 120. 70 belongs to some other people. Money has a trail. Investigators do not look for human beings. They follow the money. Once you follow the money, you find the humans. From Zenith account 3697 to Fidelity account 4697, cash drawn, come. What did you do with the cash? And you'll find it. So, going through all of this stress in your life, avoid what needs to be avoided. And these are just pitfalls from, I'm giving you pitfalls from sources of petitions against senior advocates of Nigeria. Next slide. Now, in all, I like to put this quote before I go to taking those tidbits. A quote from Solomon, now not the Solomon of the Bible, R.C. Solomon, says, ethics is the quest for a life worth living, putting every activity and goal in its place. Knowing what is worth doing and what is not worth doing. It is also within business itself, keeping in mind what is ultimately important and essential and what is not. What serves our overall career goals at this point in time in our journey and what does not. What is part of business and what is forbidden to business. Even when increased profit, the most obvious measure of business success is at stake. The power to say no is much bigger than yes. Yes is cheap. Everyone will say yes. But the power to say no is tough. Now, having said that, I would just then like to touch on a few points that have come from, call them FAQs over the years. One of those things is when you get to the court. There is a dress code which you would have seen. Please try to abide by that. There was a reason why this body set up a committee to standardize what is the dress code. But it also embodies a few things about decorum. So you will know when to wear what is the ceremonial, what is the working robes, when to have your rosette on the little black one at the back, and when not to have it. And if in doubt, please always call into BOSAN and get the right thing so that you're not improperly dressed, especially at ceremonial occasions like special court sessions, valedictory sessions. But in any instance, it is better to be properly dressed. Now, in terms of decorum, when it's time to get to the court, language and all of those things my colleagues have talked about are pretty important. I won't repeat them. But let me mention the question about giving out your indulgence. Please protect the inner bar, for it is something we have earned and worked hard. And if you must bring in someone to the inner bar, let it be out of leadership. The courtroom is congested. It is full. Fellow lawyers, even though they're the outer bar, are standing by the door. It is a show of leadership to be able to ask one. It's not the rule. There's no harm in doing it. To join you, especially the much older non-silks. But please, the protocol is to A, ask your fellow SANs to if it's fine, because it's your collective privilege that you're about to give out. Number two, as soon as the judge comes in, renew the request. Ask my Lord if it is fine to allow given that the courtroom is full, to allow Mr. A to just join you briefly, because it's literally squatting there. Just to literally briefly be there, to not congest the courtroom. So because this has caused quarrel a lot of the time, it is also not an opportunity to take your favorite junior to sit beside you because he's helping you conduct the case. He can sit right behind you. Now, a few other things I wanted to mention. Adverts. Many people run into this needless trouble over the years. The rule is there will be no congratulations to Mr. James SAN, one of the best lawyers that just took the sale. There will be none. And the rule is literally like Ryland and Fletcher. It is strict liability. We don't want to hear that it was your village people who thought that this was the way to honor you, or the people you played tennis with decided to. In one of the instances where the person faced this inquiry, he was asked how his tennis teammates got his fully robed photograph. And then used it in this day. So please tell them out of love for you that you don't need any problems. There's no need for that. There are many ways they can celebrate you other than that advert. And this is a resolution of the NBA, not BOSAN.
Yes.
We're part of the Nigerian Bar Association. They have their good reasons why they took the resolution to disallow advertorials and congratulatory messages. And please, that rule is absolute. Don't say that, no, this was only put on LinkedIn or Twitter and not this day. It's all the same. So please abide by it, that we don't have any problem. I would like to pause because there are often questions that you might want to ask along this kind of lines. Things that you're not sure of. And I mean, if you remember them anytime, please ask it to the BOSAN Secretariat, and we'll be happy to provide you with answers. But I thought to announce this absolute restriction so that nobody runs foul. Over the years, one or two people did and got sanctions for it. I will then assure you that we will get in the report of this training and the names of those who met the mandatory requirements to the LPPC this week ahead of your induction and swearing in on Monday the 27th. Thank you very much for listening, and I'll pause here to take questions.
So you just mentioned mandatory requirement. What is the mandatory requirement?
Mandatory is what you have done today.
Okay.
Had to be done. We will issue you. This is the list of the people you may go ahead and swear in they have attended this program.
Post-free observation in the publication of senior advocate in Nigeria. It's not just it's that we cancel it.
Just an observation. Number 63, Anna SAN is diseased.
My name is Isaiah Bozima. Mine is just a clarification. I note the point made regarding advertorials on print on social media. My question is, to what extent, if at all, are we allowed to say express gratitude for being conferred with the rank? If we put that, for instance, I'm delighted to be conferred with so and so, does that flout the rules? And if somebody else does that without our knowledge, to say, well, I attended X event where, at which James SAN was confirmed, just so we are properly guided and nobody runs afoul of those rules. I'm grateful.
Thank you. It'll be imputed to you once it bears your name. So that I do recognize that someone who is envious of you might take out an advert, but this is the absoluteness of the rule. So no one should do it. Now to the first question, can I go and take out something and say I am happy to be? It will be classed as such. For me, just leave that day quietly, take your oath, take your silk, and be an SAN. There's no need to have people give you problems you don't need. That's just my approach to it. You just don't, there's some problems you don't need on a happy day. So please let all those who are close to you know. And as a matter of fact, even the newspapers now know. You take it to, because people who have their adverts on this day have gone to challenge them. Why did you do this to me? And I have this problem. So please, as much as possible, avoid it. I recognize that it may slip and happen. When it happens, the panel will look into it. But do you want to start your being an SAN with a panel? I personally wouldn't have wanted that, so that's the reason. Yes, please, the microphone is.
No more because as well.
727.
Yes, 727.
Thank you so much for this. This is why I personally.
What Isaiah asked, and this is becoming the senior advocate of Nigeria, obviously is a professional milestone. And there are some professional sites like LinkedIn. So I guess maybe he didn't ask that question, I haven't asked him that question. How does, stating it on LinkedIn, on our LinkedIn profile after confirming, how does that resonate? Thank you.
Year in, year out, MBA has been resolute, administration after administration, that they're not going to change the rules. Like I said, it's not a BOSAN rule. The only reason why we emphasize it at the body of senior advocates induction is to avoid problems for our own. Because the MBA is the one who doesn't want that at all. Now, I don't want to link the two, but I told you you're now part of 0.3%. And if the 99.7% say they don't want it, maybe if we go to another bar conference, we try and change it. So it's also said that social media, print, and I would class LinkedIn, in my own humble opinion, as social media. So somebody may take it on and say it's a congratulatory message, it's an advertorial. I would stay away from it. And please, pardon me, we're not trying to dampen your bright moment. All I'm saying is that over the years, it's been a problem, a recurring problem, and that's why I make a point to announce it and remind everyone again, so that you don't discuss it by facing a panel. You just know upfront.
Thank you very much, sir. I want to make a clarification. For example, maybe some of us that may be having their receptions of program, and they want to publish in their program, maybe letters written to them, congratulatory letters to them. Can they put them in the program? Is it maybe your kinsmen have written to congratulate you, or your colleagues? Can you put them and let them in your program? Will it amount to advertisement as well?
You're able to assure me that we will not receive a petition. Because we don't go around looking for people. We receive petitions. So if we receive a petition, it means somebody saw it beyond your kinsmen. Right. So I think. Yeah. So I think the important thing is, and please let me say this: this rule is now nearly 10 years old. It's 10 years old. Imagine the number of people who have been preferred with the rank in the past 10 years. They face the same thing. Prior to that, you could take out Guardian. In fact, people had 6 to 7 pages of Guardian and this day and so on. But this is now the resolution of the MBA, of which you're all members of, and could have challenged this rule before now. If you go now to challenge it, they'll tell you it's because you're going to benefit from it. But this remains a rule as it is. I'll take the last. Yes. It created a sense that the others who did not take the rank are now not successful lawyers. This is their perspective. Okay? That is the basis of that resolution. And so that when they're on that day, they're being glorified and congratulated, and their tutorials, some in their gown, some not in their gown, that it gives them a sense of stratification of the profession. And don't forget, I started by saying that you are 0.3% of the profession. So that's the mischief. If you're able to, whatever you're mentioning now, as long as you don't get into that mischief, I will not be able to amend the resolution of the MBA. So I take it that we're done, and on this note, I would like to thank our distinguished panelists, facilitators, for helping make this session good. And I will now pause and invite the coordinator of the Body of Senior Advocates Induction Program. You shouldn't be surprised that he has put together a program of this nature. This is a far smaller number than he had to deal with all his life, molding and graduating lawyers, telling them how to carry themselves as members of the profession. But just before I call it, because someone mentioned, distinguished sales Mr. Mbanefo mentioned about dining. I'd just like to say something. Please distinguish between the practice of law and the business of law. They're not often the same thing. And that is why some of your very brilliant classmates didn't get as far as you may have. You may now need to pay some attention to the business of law, meaning how your practice is organized, how your personal brand and your office is depicted, how you wear the rank, how you grow your profession, how you charge your fees, how you progress. And so it's not entirely out of place if you took some learning skills on business education. It doesn't have to be with a particular business school, but I'm just telling you that it's important how you project yourself going forward. And so it was known by the people who brought this profession to us that social skills and socializing is a part of the profession. And hence the point he made about dining and wining. There were opportunities to socialize. The food was irrelevant. The drinks were secondary. It was the socializing that was more important. And even at this stage, we need to continue to do so. On a final note, as between ourselves as SAMs, there should be no rivalry or competition or argument in open court or before clients or laymen. This is the stage where you should glorify yourselves, praise one another, show deference, for you are now in the 0.3% of the profession. Thank you.
Hello, distinguished senior advocates. We have come to that stage when we can look back on what has happened today and do a summary, or as Mama Mrs. Shilanke would like to say, we say in peroration, what have we done? The rapporteurs will bring up a communique on proceedings, which will be forwarded to you electronically. And also, if you look at the program, you will see an item there, contribution from Chief Mrs. Folake Sholanke, CONSAN. She has actually sent in a paper, an address to you, which is an address of exhortation about the do's and don'ts of the inner bar and what would guide you into greater heights as members of the inner bar. That too will be sent to you electronically, which you are encouraged to read through and learn from own experiences as a senior advocate of Nigeria. Now we're going to present you with certificates and plaques and I think some other memorabilia of the body of senior advocates. As Professor Adubu said, alibi to show that you are actually here so that if by chance you are not seen on the channels or some other news media as having attended, your wife will not say you did not go there. At least you will have real evidence that you are here from morning till late afternoon. So we'll do that. But before doing that, let me say some words of appreciation to all those who have made this event to be possible. I know that will be done at the end, something is there, but there's something I must mention at this stage. You know, the keen interest of senior members of the inner bar at ensuring that those who are coming in are well guided is most impressive and appreciated. Now, Mr. Mbadefo, for example, came in this morning from London. And when the program was being put together, he had said that he will be away. Unfortunately, this day happened to be the day he was to return. Now, that's not the end of the problem. Usually when people come in on an early morning flight, they want to spend most of the day, resting.
Yes.
And he still accepted and insisted that he will be here. And he's here with us. Thank you very much, sir, for being a man of your words. Your word has been your bond, and we appreciate it very much. Same goes for the other facilitators. Some of them are not here now. But those who are here, I say a big thank you to Dr. Atake, Imofe Atake. I hope I pronounced the name well. Senior Advocate of Nigeria, thank you very much. Mr. Dele Adeshino cannot, if I don't thank him, he cannot complain. Because he's at home. Thank you very much, Mr. Dele Adeshino. Professor Yedisi, thank you very much too. At the formal vote of thanks, more appreciation will be made. We should go straight down to the presentation of certificates and plaques.
when I received the letter I was to come to Lagos, I complained to myself, why should these people worry us? At the peak of the celebration, what we are suffering, I don't know if you people are suffering like myself. I don't know. I said, do I really need this sound? If this is the condition, if it's a condition for having sound, I think I can, let me have some rest, you know. But coming today, honestly, it was a mistake. And I'm so happy. I didn't know we have such a level of organization in the BOSAN organization. I had said to myself, an old bull like myself, what else do I have to learn about legal practitioners, ethics, or so? Or I've learned, I thought, but today I've learned a lot. I've learned a lot. And I'm so happy. Shows we still have some hope, because I used to be an optimist about Nigeria, but now I'm a pessimist. And of course, you know, they say that pessimists were once optimists. But today, I'm going to crawl out again from pessimism to optimism. Because I feel a level of organization which I didn't imagine was there. And for this, on your behalf, I want to thank BOSAN for this organizational ability, for what they have done. I've really enjoyed myself. And I have written into the suggestion box that this program should be extended to our wives in future. It's very important, because not only do you have senators' wives, governors' wives, family officers' wives, but you see, our wives, they bear the brunt of the practice. And our husbands, they bear the brunt. If they follow us, I've also said we should have some form of tourism attached to it. So we come here, they can have a bus to take us around Lagos. And then we move it sometimes to Abuja. We do the same thing for Abuja. Maybe either on a yearly or biannually, you know, because it will help cement. When you burn the midnight oil, your wife will know why you are doing it. Your husband will know why you are doing it. One day, you take him, even the children, and you will relax. That was what we used to do during the bar conference. You know, it's a holiday. It's a sort of holiday. So we can start, or will I say, they can start, because we are not yet signed. They can start their own holiday, and the wives should be the better for it. So, on your behalf, I want to thank the BOSAN organization and the lecturers who came here today to lift our spirit and give us insights and peep into what is to come. Particularly my good friend who left London last night. By now he hadn't left London. the distinguished LNN, the son, SAN, my friend and classmate, you know. It's not easy to have that flight, come back from the airport, and still come and give lecture the same a few hours. So we say thank you very much for coming to help us. When I talk of Mr. Is he a chief or Mr. Atake? Oh, Dr. Atake, SAN. The story he told us today, we have to learn lesson from it. Very interesting, kept me, if I speak for myself, on the edge of the seat. You know? And we should learn, in short, we should learn from it. Thank you very much.